Mr. Greenie, good morning.
Good morning, sir. The purpose of the hearing over the course of what is currently planned to be the next 2 days is to address two pressing issues. First of all, His Majesty's Government, HMG, has disclosed relevant documents to the inquiry already and will continue to do so. Many of those documents contain the names of junior officials. That is to say, junior civil servants who were not, at the time the relevant document was created, members of the senior civil service. HMG submits that the names of all junior officials should be redacted from the documents before they are disclosed to core participants. So that is the first issue. Second, the Police Service of Northern Ireland, PSNI, has also disclosed relevant documents to the inquiry and will continue to do so. Some of those documents contain the names of persons suspected of involvement in the Omagh bombing and/or in other terrorist activity. PSNI maintains that as a matter of principle, the name of any suspect, unless charged, should be protected from disclosure. As we understand it, their position is that the inquiry should take into account this principle, if that is what it is, in the decisions that are made as to disclosure on to core participants of the documents that name suspects. So that is the second issue. Sir, in our assessment, it's important to emphasise three things at the outset. One, neither HMG nor PSNI is suggesting that the documents should be disclosed in a redacted form to the inquiry. That is to say that it is acknowledged that the inquiry should see those documents unredacted. Two, what is in fact an issue today is whether those documents should be redacted before they go to core participants, all of whom have signed a confidentiality undertaking. And three, whether the document should later be disclosed unredacted during the course of the oral evidence hearings, that is to say in public, is an issue for another day, if it remains in relation to any particular name contentious at that stage. So can we be clear that we are not today dealing with the issue of disclosure of the names of either junior civil servants or suspects to the public, only whether documents containing such names should go unredacted to core participants. So we would invite all core participants to focus on what is truly for argument today, not on what may be argument for another day. To return to the two broad issues, so that is to say the junior officials issue and the suspects issue, those issues, although separate, both give rise to matters concerning the relationship between several rights preserved or guaranteed by the European Convention on Human Rights in the context of a statutory public inquiry. And that is why a single hearing has been arranged to hear argument in relation to both issues. So would you bear with me for one moment, please? So, sir, as I was explaining, that is why a single hearing has been arranged to hear argument in relation to those two issues. It's also worth noting that it's been necessary to arrange this hearing at relatively short notice. And that's because it will not be possible to disclose to core participants a considerable body of material that contains the names of junior officials and/or suspects until the issues have been resolved. Accordingly, the current position of HMG and PSNI is putting a brake on the work of disclosure of the inquiry. So that is why it is so important to resolve those issues today, or at least for you to hear argument in relation to them. We have referred to the relationship between several rights. The rights to which we were referring are these. One, the absolute right guaranteed by Article 2, namely the right to life. As everyone we expect will know, this imposes three separate obligations on the state. First, the negative obligation not to take a person's life save in specific circumstances permitted in law. Second, the positive obligation to protect life. And third, the procedural or investigative obligation to conduct an effective and independent investigation into a death where the positive or negative duties have arguably been breached. So that is the first right. 2, the qualified right in Article 8. So the right to respect for private and family life. Article 8 provides that there shall be no interference by a public authority, and pausing for one moment, there is no doubt that this inquiry is a public authority, with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interests, so far as is relevant, of the protection of the rights and freedoms of others. 3, the qualified right in Article 10. So, as all will know, the right to freedom of expression. This is qualified in a number of ways. Article 10 is not, it currently seems to the inquiry legal team, a right that arises for close consideration today, if any consideration, given that we are concerned only with disclosure to core participants and not today to the public at large. But we wish to emphasise that Article 10 will plainly be of a high degree of relevance when the question of disclosure to the public arises. Although the submissions of the media will be particularly important at that stage, that later stage, we suggest that you would benefit from hearing from their representatives during this hearing also, to the extent that they wish to develop their written submissions orally, so that you can have the Article 10 issues well in mind throughout the course of this inquiry. So against that background, we're going to turn now to the 2 issues. So the junior officials issue and the suspects issue. And we will develop our submissions in one go, if we can put it that way. And we would invite others who wish to address you orally to do the same. So that is to say, we are not going to break our submissions, nor should anyone else break their submissions down into the separate issues, save to the extent that they have submissions only on one of the 2 issues. In what we next say, we intend to do the following. First, to set out what seem to us to be the applicable principles. Secondly, to set out certain provisional views, and we emphasise that those views will be provisional and dependent upon what we hear over the course of the balance of today and tomorrow. And third, sir, we intend to pose several questions that we believe you would benefit from hearing from core participants on, if they have an opinion and view on them. So we'll begin by addressing the junior officials issue. Before we turn to the substance of HMG's position on the redaction of the names of junior officials, it's necessary for us to set out some of the history of the HMG application. On the 6th of March of this year, the inquiry legal team wrote to HMG by email to state that if HMG intended to make an application to you, sir, to redact the names of junior civil servants from the material disclosed to core participants, then HMG should do so by no later than 4 p.m. on Friday, the 14th of March. The email read, to the extent that is relevant to the issues today, quotes, if GLD, the Government Legal Department, intend to make an application to the chairman on this issue, I would be grateful if it's lodged by no later than 4 p.m. on Friday, the 14th of March, that time and date being highlighted. The email continued, as it stands, there are 80 documents being withheld from disclosure pending this application, and we pause to note that even at that early stage in March of this year, as many as 80 documents were having to be withheld from disclosure. The email continued, please do ensure that any application makes reference to each of these documents as far as relevant and identifies the issues of concern within each one to assist with the consideration of any application that is made. And there the email ended. An application was made by HMG on the 31st of March, 2.5 weeks after the date that had been set in the email. When the inquiry legal team asked HMG whether there was any reason why that application could not be shared with other core participants, HMG formally withdrew the application because, quotes, it had some sensitivities which ought not to be shared with CPs and the media, end quotes. And so can we make clear that those words that we have just quoted are a direct quote from the final open application. On the 15th of April, so just over a month after the date originally set, HMG submitted the application that is between pages 2 and 4 of the bundle that has been circulated to all core participants. The application sought the redaction of civil service names and addresses, and so we understand that to be a reference to email addresses, from documents before they went to core participants, and it gave reasons for the application. The application was accompanied by a 5.5-page witness statement of the Deputy Director of the Legacy Group, Northern Ireland Office. The inquiry legal team proceeded on the basis that the application and witness statement formed the basis upon which the inquiry and the core participants should consider HMG's position. So in other words, sir, we considered, and we anticipate that core participants considered, that this was the argument with which we and they needed to engage. Neither the application nor the witness statement suggested any intention to serve any further submissions, nor, sir, as we understand it, was that prospect raised in any correspondence with the inquiry. It was therefore with considerable surprise and some frustration that at 4 p.m. on the 20th of May, so yesterday, and therefore the day before the hearing was scheduled to start, and moreover in circumstances in which we suggest it ought to have been anticipated that members of the inquiry legal team and the chairman, and indeed core participants and their representatives, would be travelling to Belfast. In those circumstances, a skeleton argument was emailed to the inquiry legal team by the Crown Solicitor's Office. The skeleton argument was stated to be on behalf of the Northern Ireland Office. The inquiry legal team had not previously received any correspondence from the Crown Solicitor's Office on behalf of the Northern Ireland Office, or previous communication having come from the Government Legal Department. The inquiry legal team regards the unexpected service of a skeleton argument at such a late stage as highly unfortunate. One, although the skeleton argument purports in certain respects to respond to the submissions of core participants, in large part it develops arguments, including by reference to authorities, that could, we judge, have been developed 5 weeks ago and, we suggest, should have been developed 5 weeks ago. And there has currently been no formal explanation for why that was not done. Two, the service of a skeleton argument at such a late stage deprives both the inquiry and the core participants of the time to which they are entitled in order to prepare their response. And it places an unacceptable burden on all involved in this process. And we suspect that all core participants will have shared the inquiry legal team's surprise and frustration at this turn of events. Three, and without wishing to overstate this, it hardly needs to be said that this inquiry is about whether the Omagh bombing could have been prevented by UK state authorities. And it's also notable that this hearing, the hearing today and tomorrow, concerns issues that could be described as ones involving transparency. So it might be thought that HMG would have been scrupulous to avoid the impression that it was behaving in a way that was procedurally unhelpful and possibly even unfair. And there seems to the inquiry legal team a risk that the approach taken by HMG to this hearing will undermine public confidence in HMG's approach to this inquiry. The inquiry legal team has an additional concern about the approach taken by HMG to the late service of its skeleton argument. As we have said, at 4 p.m, the skeleton argument was received by the inquiry legal team. Just over half an hour later, using the email distribution list of the inquiry legal team, the Crown Solicitor's Office, which was not itself on that distribution list, sent that skeleton argument to all core participants. This was both unnecessary, because the inquiry legal team had the matter in hand. Indeed, the solicitor's inquiry had circulated the skeleton argument to core participants at 4:13 p.m, 13 minutes after it was received, and also likely to cause even further confusion and distress, and potentially undermine the inquiry legal team's relationship with the core participants, since they will have received an email out of nowhere from someone whose role they may not have understood in our process. By way of mitigation, can we make clear that it appears that the lawyer in question at the Crown Solicitor's Office had misread an earlier email from the solicitor to the inquiry and was acting in the belief that the skeleton argument, served on the solicitor only a very time short before, had not been circulated to core participants. As we've made plain, it had. We, the inquiry legal team, accept that this mistake was made in good faith, which mistake has been candidly accepted. For this reason, we have not named the individual responsible, and we also acknowledge that steps were taken to undo what had been done when the error was pointed out. However, this incident only serves to underline what appears from the outside to have been a chaotic rush to provide materials at the very last minute. Sir, we suggest that this state of affairs calls for a clear and candid explanation from HMG, following which no doubt we can put this behind us. And we will invite HMG, through Council, to give that explanation at the commencement of their submissions, which will follow on immediately after ours. So, having unfortunately had to begin this hearing with those remarks, we'll turn to the substance of HMG's application. So that is to say, the application to redact the names of junior civil servants from documents before they are disclosed to core participants. As we've explained, this application is set out in a letter of the 15th of April and is developed in the witness statement of the Deputy Director of the Legacy Group of the Northern Ireland Office, that statement having the same date. And now, of course, we have the skeleton argument too. In short, HMG submits that the names of junior officials should be redacted from documents for 3 reasons. 1, the naming of these individuals has no relevance, it is said, to the work of the inquiry. So the first reason, irrelevance. 2, the naming of these individuals, it's argued, would undermine their expectation of privacy and confidentiality. So reason 2, privacy. And 3, the naming of these individuals, it is contended, will increase the risks to them given the context of the work of the Northern Ireland Office and the inquiry. Reason 3, risk. And what we'll do, sir, in the hope that it will be helpful both to you and to core participants, is to deal with each of those reasons in the order in which they have been identified in the letter and in the skeleton argument. As for the assertion of irrelevance, so there are a number of matters upon which we consider you would benefit from the submissions of core participants. First, as will be obvious to everyone, the inquiry is at an early stage in its disclosure process. The current view of counsel to the inquiry is that it is not possible at this stage, and may be dangerous, to make the decision that the name of any particular junior official is irrelevant, such as to justify redaction from documents before they go to core participants. Connectedly, we do not currently understand how it can be safe to assume that the names of junior officials as a class are irrelevant. It currently seems to us, the inquiry legal team, that the safe and appropriate course is to assume that where in any particular document of relevance a person is named, that name is relevant until a point at which it can be seen that the name is, to the contrary, irrelevant. And that point, without question, has not yet been reached. Accordingly, sir, we consider that you will be assisted by hearing from core participants on the question of whether HMG is approaching this issue from the wrong end. Is it appropriate to presume that the names of junior officials are irrelevant, particularly given the stage that the inquiry is at? Second, HMG submits that the answer to the problem, or at least a substantial part of the answer to the problem, is that the inquiry legal team will see the documents unredacted, unlike the court in IAB, a case to which we'll shortly turn. That proposition appears to the inquiry legal team to assume that the inquiry legal team has a monopoly of wisdom and that the core participants could add nothing to our understanding of relevance. Currently, counsel to the inquiry regards that proposition, if it is what HMG's position boils down to, as wrong. At the risk of stating the obvious, within the bereaved family and survivor core participant groups are people who have spent decades campaigning and who, as a result, have a detailed knowledge of some of the issues, perhaps many of the issues, that we will be exploring over the course of this inquiry. We have the Police Ombudsman for Northern Ireland, which has also looked closely at some of these issues. And we have other core participants with detailed knowledge as well. And it currently seems to us that it is plainly realistic to imagine that a core participant may see something in a name that the inquiry legal team does not. So we consider that you will benefit from receiving submissions on that analysis. Is it correct? And what difference does it make if it is? Third, on the purported reason of irrelevancy, many of those who have made submissions to in writing, sir, have pointed out that the High Court and the Court of Appeal of England and Wales consider the redaction of documents by HMG in the IAB case. So that is to say, the courts in that case consider the redaction from documents of the names of junior officials. HMG is clearly correct to point out that the context for that case was a claim for judicial review, and we'll address that difference as we go along. But you, sir, we suggest, will need to consider to what extent the courts in IAB were expressing principles that apply equally to the situation that you are concerned with. So to what extent does that which was said in IAB read across to the circumstances of a public inquiry? Mr. Justice Swift gave detailed consideration to the issue of relevance at paragraphs 14 to 22 of his first instance decision in IAB, the facts of which, sir, do not particularly illuminate the principles to be derived from it. His conclusion appears at paragraph 22, and, sir, for your note, and in case you want to turn it up, that conclusion appears at page 117 of the inquiry's authorities bundle. And so for those who don't immediately have that authority to hand, we'll read out the relevant part. Mr. Justice Swift said the following, and we quote, "Drawing these points together, the principle which ought to guide the approach in judicial review proceedings is that, absent good reason to the contrary, which might, for example, include that the information in question was subject to a legal obligation of confidentiality, redaction on grounds of relevance alone ought to be confined to clear situations where the information redacted does not concern the decision under challenge. The names the Secretaries of State seek to protect are not in this class. names of civil servants should not routinely be redacted from disclosable documents. Redaction should take place only where it is necessary for good and sufficient reason. This conclusion is consistent with the obligation of candour and with the general principle of cooperation between public authorities and the court that is one foundation for judicial scrutiny. This approach will also guard against the practical difficulties caused by excessive redaction. End quote. It is right, as HMG points out, that this conclusion was expressed in the context of the duty of candour in judicial review proceedings, and that what was an issue was redaction of materials before they went to the court, although presumably they would have remained redacted when they went on to the claimants. But notwithstanding that was the context for the decision of Mr. Justice Swift, it's useful to look at some of the reasoning by which he reached that conclusion. And so, sir, I'm going to turn, having made that remark, to paragraphs 18 and 19 of the judgment, which you'll find, sir, I think at pages 117 going on to 115, thank you, going on to 116. And so I do appreciate that for the lawyers in the room, it may be rather tedious for me to read out whole parts of a judgment, but we bear in mind that there are others in this room who are not lawyers and who will not have read these authorities before.
So just bear with me a second, Mr. Greenie. I'm going to see if I can just turn up the case reference. In our bundle, what page are we on? If you're looking at it electronically, sir, as I think you are, yeah.
It's pages 115. It's pages 115 to 116. Thank you very much, Mr. Delapour. I was just saying he had it wrong and he had it right. So this was Mr. Justice Swift. This was Mr. Justice Swift quoting from the judgment of the Master of the Rolls in the well-known Huddleston case. And we can hand up a hard copy of the bundle, sir, with that page turned up, if that's helpful.
I think I've got them, actually.
So it's within the hard copy bundle, it's divider 6. And it's the pagination in the top right-hand corner, so page 115 of 458. I'm sorry, sir, that you were struggling with the electronic version.
I think there's an issue with the electronic version.
So there is an issue that certainly in my version of the electronic bundle, it was always on page 16, even if it was on page 115.
So we're looking in the first instance case?
We're looking at the first instance case, so the judgment of Mr. Justice Swift, and wherein it was paragraphs 14 through to 22. Yes. So we're at paragraph 7 of the judgment of Mr. Justice Swift, page 115, where he cites paragraph 17 and following of the judgment of. Would you bear with me for a moment, sir, please? Where's the first instance? Decision isn't there. What I'm going to suggest, sir, is if you would rise for just a few moments so that I can sort these bundles out, because there seems to be a problem in our bundle as well.
you'd like me to do that, Mr. Greedy?
Yes, I'd like
All
it
right.
just for a few moments, so that's the easiest way of dealing with it.
Mr. Greeny.
So, sir, I'm very sorry about that and about the delay. The confusion has arisen because the first instance judgment of Mr. Justice Swift is not within either your electronic or hard copy bundle. And so I take responsibility for that omission, which is unfortunate.
Well, I have it separately downloaded, so I've got it in front of me anyway.
Do you? Right. Well then, sir.
And it's also quoted, of course, in the Code of Appeals.
It is quoted. So let's just take a step back so that this does all make sense, both to you and to everyone else. So I had drawn your attention to paragraph 22 of the ruling of Mr. Justice Swift, in which he rejected irrelevancy as a basis for redaction of the documents before they went to the court. And at the very end of paragraph 22, the learned judge identified that the approach that he was proposing, quotes, will also guard against the practical difficulties caused by excessive redaction. The judge had dealt with the, quotes, excessive redaction at paragraphs 18 and 19 of his ruling, and so that was what I was seeking to take you to just before you rose. And I was indicating as well that so that everyone could follow, I would read out those paragraphs, and that is what I'll do now. So paragraph 18, redaction leads to significant practical difficulties. The present case is an example of a common situation where email exchanges and other contemporaneous documents are disclosed to explain a decision-making process. Most decisions made within central government now involve significantly sized groups of civil servants. On any occasion, one civil servant within the group might be the sender of the message, might be the recipient of the message, or might, usually will probably, be copied in. Sometimes, as in this case, the civil servants within the group are spread across different government departments. And then the judge said this: at the least, redacting names makes the decision-making process and the significance of each document disclosed more difficult to understand. In some instances, it may obscure the significance of a document almost completely. When correspondence and other documents are disclosed for the purpose of evidencing a decision-making process, it will rarely be the case that it will not assist the court's understanding of that process and the decision itself to know by whom or to whom the documents were sent, forwarded, or copied. In most cases, when this information is redacted, any outsider's understanding of the documents, and for this purpose the court is an outsider, pausing for a moment, and so will be the court participants, is significantly hampered. Misunderstanding and misinterpretation become commonplace. When documents are disclosed and parties then rely on them by including them in the hearing bundle, the court is under a practical obligation to consider those documents with a view to making sense of how the information in the documents bears upon the legality of the decision under challenge. All of this is made much more difficult and more time-consuming when, for example, successive strings of email correspondence, each page as long, are entirely anonymised. The same point applies to names redacted in the body of correspondence or other documents. All such redactions only detract from the intelligibility of the document and impair achievement of the purpose for which the document was disclosed into the litigation. And paragraph 9 of the judgment read, 19, forgive me, of the judgment read, the Secretaries of State's response that any concerns are about no more than making reading documents a little bit easier is glib. First, ensuring that documents disclosed in litigation to explain a decision-making process are readily intelligible is an objective worth achieving for its own sake. It is notable that the Secretaries of State's proposal to deal with problems of intelligibility, both in this case and generally, was to replace redacted names with a list of ciphers, an approach that would be laborious, prone to error, and even when error-free would only add a new layer of complexity to the task of understanding the narrative of the decision-making process from the documents disclosed. So the reasoning of Mr. Justice Swift was upheld by the Court of Appeal. So what assistance can be derived by the inquiry from the ruling in that case? The position is that whilst the practical difficulties described by the judge in the passage we have just read out will not affect the inquiry legal team, because we will, as I've said, see the documents unredacted, on the face of it, those difficulties will affect core participants if they receive the documents redacted. So we hope that that submission is plain. We will not be affected, but the core participants will be affected in each of the ways described by Mr. Justice Swift. We therefore consider that you will be helped if the core participants address the following issues. 1, are we correct that these practical difficulties will affect core participants? And what is the significance of this, if any, to the argument on relevance? 2, how does this point interact with the second point, namely the point that the inquiry legal team currently assesses that core participants have an important role to play in identifying whether any particular name is relevant? And 3, what is the relevance of the fact that the argument in IAB arose in the context of the duty of candour in judicial review proceedings? So, sir, that is all we propose to say about the reason advanced for redaction of irrelevancy. As for the argument based on the asserted expectation of privacy and confidentiality on the part of junior civil servants, again, we consider that you will benefit from submissions by core participants on a number of issues. In IAB, HMG made an argument that seems to us to be materially identical to the argument, sir, that is advanced to you. And Mr. Justice Swift rejected it. And, sir, if you are in the first instance judgment, could I invite your attention, please, to paragraph 25 of Mr. Justice Swift's ruling, which is the paragraph in which he reached his conclusion about the ground advanced in that case of privacy. And what the judge said was this, and I quote, "I do not consider any such general expectation," so a general expectation of privacy, "even assuming it exists in practice, could be reasonable. No such expectation would attach to any person as a matter of general employment law. Moreover, when at work, civil servants are not involved in anything that can be described as a private activity. They are exercising public functions as part of the public service of the country. It is also material that while the Secretaries of State's submission refers to the class of junior civil servants, this label was applied only to distinguish them from the civil servants working in grades comprising what the government refers to as the senior civil service. Therefore, the distinction between junior and senior civil servants is akin to the distinction between junior and leading counsel and is not necessarily any indication of age or experience. The class of junior civil servants includes civil servants with significant responsibilities. End quote. So Mr. Justice Swift roundly rejected an argument materially identical, so it seems to us, to that advanced before you, sir. As we've observed, the Court of Appeal of England and Wales upheld the ruling of Mr. Justice Swift and did so, moreover, for the reasons that he had given.
I think it's perhaps fair to say that the issue of privacy wasn't at the forefront of the Court of Appeal decision, but there were one or two passages in which the Court of Appeal looked at that issue. And perhaps at paragraphs 31 and 32 of their decision.
Indeed, sir, yes.
Where there was a discussion on guidance documentation that was provided to civil servants about their duties, particularly in relation to candour and disclosure in judicial review proceedings. And the court pointed out at paragraph 32 that there's no mention in any of that guidance of any practice of redacting names, and concluded that it's difficult to see how any civil servants conscientiously reading the guidance document could have had an expectation that their names should be withheld as a matter of routine in judicial review proceedings.
So we quite agree that that is an important passage in the ruling of the Court of Appeal.
And in the final sentence of the Court of Appeal's judgment, the practice is inimical to open government and unsupported by authority. If Parliament takes the view that members of the civil service have a general right to anonymity in judicial review litigation, then it should enact a primary statute to that effect.
Which it has not done, sir.
Yes.
So the Counsel to the Inquiry currently regards the reasoning of Mr. Justice Swift on the issue of expectation of privacy as applying with equal force to the issues confronting the inquiry. In his ruling, Mr. Justice Swift clearly appears, we would submit, to be making a point of general application, not one that applies only to judicial review proceedings. The question that we invite court participants to address is whether that assessment of Counsel to the Inquiry is right or not. In connection with the privacy argument, the skeleton argument of Counsel to the Inquiry raised two questions of HMG, and the questions were in these terms. First, as has been pointed out to HMG, we said, many of the junior officials whose names it proposes should be redacted have publicised the identity of their employer via social media. Does that make a difference? So the point we were making was that far from hiding the identity of their employer, many junior officials whose names had featured in documents that we had seen have publicised that fact on social media. The second question we posed was in these terms. Some of those who were junior officials at the time of the creation of the relevant documents are now members of the senior civil service. Does that make a difference? Does HMG, we asked, submit that it's the position of the individual then or now that is important? And if the former, why so? So we have noted HMG's response to those questions at paragraph 33 of its skeleton argument. We invite HMG to make clear whether, assuming for a moment that a junior official does have a reasonable expectation of privacy, it does or does not accept that those who have publicised the identity of their employer via social media and those who are now members of the senior civil service still have that reasonable expectation. And also, we invite core participants to address the significance of these matters generally. And finally, sir, on the issue of privacy, we invite HMG to identify the evidential basis, if there is one, for the assertion that junior officials have a reasonable expectation of privacy, particularly bearing in mind the passages from the judgment of the Court of Appeal to which you, sir, have just drawn attention. As for the assertion of risk, in the case of the Crown, L1T FM Holdings UK Limited and others, the citation for which is 2024 EWHC 386 admin, a class-based argument similar to that advanced by HMG before you, sir, was rejected by Mr. Justice Swift. And, sir, I say with some trepidation that you should find the relevant part of that ruling at page 170 of the electronic version, and if you were to be working from the hard copy version,
I've got it on my own collection.
You have it, sir. So I'm referring to paragraph 26 of the ruling, this separate ruling of Mr. Justice Swift in this different case. And again, so that all who are watching online or present in the courtroom can follow the argument, I will read out in fact, two paragraphs that we particularly emphasise, paragraphs 26 and 27. At paragraph 26, Mr. Justice Swift said, further, the Secretary of State relies on evidence in a witness statement made by Jacqueline Ward, the Director of the Investment Security Unit. The latter part of that evidence is under the heading Confidentiality and National Security. Ms. Ward explains that the identity of civil servants who work on decisions taken in exercise of the powers in National Security and Investment Act 2021 may be of interest, quotes, to those seeking to undermine the UK's national security, such as hostile actors. Her evidence, continued the judge, is that this reason applies to all civil servants not working in senior civil service grades and is a sufficient reason to redact their names from the disclosed document. So pausing for a moment, as we submitted a class-based argument relating to risk similar to that advanced before you, sir, was an issue in this case. Paragraph 27, the judge said, I disagree. Ms. Ward's statement does not set out any specific national security reason for the redaction of the names of all civil servants in junior civil service grades. Leading counsel for the Secretary of State accepted that there was no national security assessment to the effect that all such names needed to be redacted. The Secretary of State's general application that the names of all civil servants outside the senior civil service should be redacted, therefore fails. The provisional view of counsel to the inquiry, sir, is that the reasoning of Mr. Justice Swift in that case applies to those referred to in HMG's application. And we invite all court participants, to the extent that they wish to do so, to address whether that is correct. So in other words, so what we read from that judgment is that class-based risk arguments, particularly when not evidenced or not adequately evidenced, are not good enough, that there needs to be consideration of individuals on a case-by-case basis. Which leads to the next point, which is that, of course, if in the case of any particular junior official, that person's Article 2 rights are engaged, the inquiry will respect those rights, and or if their Article 8 rights are engaged in a way that outweighs other legitimate interests, the inquiry will respect those rights too. In those circumstances, the redaction of the name will or may be justified. However, our current view, sir, is that any such issue must be addressed on a case-by-case basis, not on a class basis. Accordingly, the provisional view of the inquiry legal team is that the assertion that the names of junior officials should be redacted from disclosure to court participants on a class basis, described by some court participants as a blanket basis, due to an asserted but unevidenced generic risk of harm, is one that you should reject. Again, however, you will no doubt be assisted, sir, by the submissions of court participants on this point, both those you have received in writing already, for which we are grateful, and those that you receive orally today and/or tomorrow. And this should, we suggest, include submissions from HMG on what, assuming the risk argument could succeed on a class basis, the evidential basis for the asserted class risk really is. There are two final points upon which we consider you would be assisted by submissions of the core participants in relation to this first issue, the junior officials issue. First, the duty of candour. We know, sir, that we are on safe ground in submitting that you will expect complete candour from all core participants, including HMG, throughout your investigation. In the opening statement protocol, the following was stated. The Chairman expects state core participants to understand and exhibit the principles of the Hillsborough Charter and the Hillsborough law. What relevance, if any, do those principles, we ask, along with the 7 principles of public life to which reference is made in the submissions of core participants, have? If HMG has a duty of candour to other core participants, what is the impact of that on the proposal to redact documents that are provided to them? The inquiry legal team notes what was said by Lord Justice Bean at paragraph 24 of the ruling of the Court of Appeal in IAB, namely that there is, quotes, no duty of candour equivalent to that imposed on public bodies defending judicial review claims, end quotes. And we would ask, in what practical way does HMG suggest the duty of candour owed to this inquiry by HMG, in what practical way is it suggested to be different from and or less than that owed in judicial review proceedings? Moreover, does any such difference, if it exists, apply to the names of junior civil servants, which, after all, is a matter under consideration? And can HMG give any practical example of something it considers bound to disclose in a judicial review that it would not consider itself bound to disclose to the inquiry? I said that there were 2 final points, and this is the second. In its submissions, certainly in the application itself, HMG makes reference to the protocols and or practices applied by other public inquiries. So we do not consider that you are likely to derive any assistance from the approach adopted in other processes. Those protocols and practices that are relied upon were not, so far as the inquiry legal team can tell, the product of any hearing at which the issues of relevance, privacy and risk were considered, let alone ruled upon. And moreover, in some cases, the protocol or practice referred to was established prior to the decision of the Court of Appeal in IAB, and we have in mind in particular the protocol of the UK COVID-19 inquiry. But in any event, sir, the approach adopted in other inquiries has no binding effect on you, and you must, of course, make your own decision. So having dealt with the principles, or at least some of them, having expressed some provisional views and having set out some questions that you may benefit from the CP seeking to answer, we'll turn away from the junior officials issue and to the suspects issue. We acknowledge that PSNI has raised an important issue that requires careful consideration. It is helpful, we acknowledge, that PSNI's position in its written submissions has been expressed in a deliberately non-adversarial way and, moreover, in a clear way. However, we expect, sir, that you will benefit from hearing from PSNI on whether their position is, on the one hand, that the inquiry should take into account the principle they identify, if that is what it is, in the decisions that are made as to disclosure onto the core participants of documents that name suspects, or, on the other hand, whether the Police Service of Northern Ireland propose that you should rule that disclosure should not be made of suspect names in any, all, or some sets of circumstance, at which stage and in which situation it currently seems to us that there would need to be an application for a restriction order, which there is not at the moment. In considering the position on the suspects issue, the starting point is Article 8 of the Convention, as set out in Schedule 1 to the Human Rights Act of 1998. And as everyone knows, Article 8 is in these terms: everyone has a right to respect for his private and family life, his home, and his correspondence. That is Article 8.1. Article 8.2, there shall be no interference by public authority with the exercise of this right except such as is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or, and we emphasise this phrase, for the protection of the rights and freedoms of others. As is obvious from its face, and as we have already submitted, Article 8 is not an unqualified right. Interference with an Article 8 right will be lawful where, inter alia, that interference is in accordance with the law and necessary for the protection of the rights and freedoms of others. On the facts of this inquiry, where the inquiry makes disclosure of the name of someone suspected of involvement in the Omagh bombing or in a potentially linked attack, as we have described them, to core participants, which of course is the stage that is currently under consideration, well, in such a situation, we currently consider that the inquiry will be acting in accordance with Section 17 of the Inquiries Act of 2005 and will therefore be acting in accordance with the law in making that disclosure. In considering next whether such a disclosure to core participants is necessary for the protection of the rights and freedoms of others, we consider that the procedural rights of the bereaved families under Article 2 of the Convention will be of a high degree of relevance, just as they have argued and as PSNI has acknowledged. So, pausing for just a moment, may we be clear that we do not ignore the Article 10 rights of the press and the public. Those rights will be of undoubted importance at a subsequent stage, namely where in any case disclosure is made or proposed to be made beyond the core participants to the public at large. So we hope we have been clear. The Article 10 rights of the press and the public undoubtedly will be engaged and will be an important consideration at that stage. Although, as we've made clear, we consider that you should nonetheless hear from the representatives of the media at this stage if they wish to develop their helpful submissions in writing. In the event that the Article 8.2 criteria are satisfied, such as potentially to justify an interference with an expectation of privacy, you, sir, will need to consider whether that interference is proportionate. And that approach, that principle of proportionality, arises from, among other cases, the case of Bank Mellet and HM Treasury number 2, 2013-39 at paragraph 74. And so we'll make sure we have that citation correctly identified in due course, but for the time being, I'll read out what was said. The judgment of Dixon, Chief Justice in Oaks, provides the clearest and most influential judicial analysis of proportionality within the common law tradition of legal reasoning. Its attraction as a heuristic tool is that by breaking down an assessment of proportionality into distinct elements, it can clarify different aspects of such an assessment and make value judgments more explicit. The approach adopted in Oakes can be summarised by saying that it is necessary to determine, 1, whether the objective of the measure is sufficiently important to justify the limitation of a protected right, 2, whether the measure is rationally connected to the objective, 3, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective, and 4, whether balancing the severity of the measure's effects on the rights of the persons to whom it applies against the importance of the objective, to the extent that the measure will contribute to its achievement, the former outweighs the latter. The first 3 of these are the criteria listed by Lord Clyde in De Freitas, and the 4th reflects the additional observation made in Huang. I have formulated the 4th criterion in greater detail than Lord Sumption, Justice of the Supreme Court, but there is no difference of substance. In essence, the question at step 4 is whether the impact of the rights infringement is disproportionate to the likely benefit of the impugned measure. And so, yes, that was paragraph 74 at page 246 of the authorities bundle. The impact of Article 8 in circumstances in which a person is investigated on suspicion of a criminal offence but not charged has been considered in several authorities. But, sir, it's necessary to note only 2 because the principles are now settled. In the well-known case of Richard and the British Broadcasting Corporation and another, 2018, EWHC 1836, Mr. Justice Mann ruled, this is page 352 of the authorities bundle, in the following way. At paragraph 248, the judge ruled, "It seems to me that on the authorities, and as a matter of general principle, a suspect has a reasonable expectation of privacy in relation to a police investigation, and I so rule." The judge went on, having cited various other authorities at paragraph 250, to say, "These judicial remarks demonstrate at least some of the reasons why an accused should at least prima facie have a reasonable expectation of privacy in respect of an investigation. They are particularly appropriate to the type of case referred to there, of which, of course, the present case is an instance, but they are generally applicable to varying extents to other types of cases." And then at paragraph 251, the judge said, "That is not to say, and I do not find that there is an invariable right to privacy. There may be all sorts of reasons why, in a given case, there is no reasonable expectation of privacy, or why an original reasonable expectation is displaced. An example was given by Sir Brian Levison in the extract quoted above, and others can be readily thought of. But in my view, the legitimate expectation is the starting point. I consider that the reasonable person would objectively consider that to be the case." In the second case to which we'll make reference, ZXC and Bloomberg LO, 2022, UKSC 5, the Supreme Court ruled consistently with the decision of Mr. Justice Mann in the Richards case, in that the court ruled that as a legitimate starting point, a person under criminal investigation has, prior to being charged, a reasonable expectation of privacy in respect of information relating to that investigation. That was paragraph 146. However, that legitimate starting point is, the court went on to make clear, no more than that. It is not, the court said, a legal rule or legal presumption, let alone an irrebuttable presumption. The determination as to whether there is a reasonable expectation of privacy in the relevant information is, the court emphasised, a fact-specific inquiry. Accordingly, we accept that the starting point in addressing the suspect's issue posed by PSNI is that a person investigated on suspicion of an offence but not charged has a reasonable expectation of privacy in respect of the fact of and information about the investigation. However, even where that expectation exists, it will be necessary to consider whether naming the suspect in disclosure to core participants is nonetheless in accordance with the law and necessary to protect the procedural rights of the bereaved families under Article 2 and is proportionate. So, sir, in a moment, having set out all of that by way of, we hope, helpful background, we're going to ask where that leaves us. But looking at the time and bearing in mind the burden on the shorthand writers, I'm going to ask whether it would be an unacceptable burden to continue for a further 10 minutes, or even 15. Thank you very much indeed. So, where does that leave us? In early correspondence, so I think the 10th of April of this year, with the PSNI on this issue, the inquiry legal team set out 7 categories of person, 7 categories of suspect. Those categories are rehearsed in PSNI submissions for this hearing, and we make no criticism of PSNI for that. But we should be very clear that what ILT was not doing in setting out those 7 categories was expressing any concluded view. So we were not saying, here are 7 categories and this is our final view in relation to them. Instead, as is, we would suggest, commonly done, we were inviting PSNI to address what were a number of examples in the hope that their answers would illuminate their reasoning. The reality, so it seems to us, is that there are a number of ways of breaking down the suspect's cohort. Some into a large number of categories, some into a smaller number of categories. Our current view, but we would welcome the views of others, is that that cohort, that group, can most helpfully be broken down into 4 subgroups. And it's on those subgroups that we invited the submissions of core participants in their written responses. Those 4 subgroups or categories are as follows. And in identifying those categories, so what we will do is not only to state what type of person falls into that particular category, but we will also set out what the inquiry legal team's provisional views are in respect of persons within that group or subgroup. So category 1, a person suspected of involvement in the Omagh bombing, but not charged, who has been publicly named in the media reporting or in Parliament, as has happened, as having been investigated. Our provisional view is that those in that category have no reasonable expectation of privacy, given that the relevant information is already public knowledge, and moreover, it is our view that even if they do have such a reasonable expectation, it is in accordance with the law and necessary to protect the procedural rights of the bereaved families under Article 2 and proportionate for their names to appear unredacted in the disclosure to core participants. So in other words, where there is a document with the name of such a person, that document should go unredacted, with the name unredacted, to core participants. Category 2, a person suspected of involvement in a potentially linked incident, by which we mean an incident potentially linked to the Omagh bombing, but not charged, who has been publicly named in media reporting or in Parliament as having been investigated. Once again, our provisional view is that those in the second category have no reasonable expectation of privacy, given that the relevant information is already public knowledge, and that even if they do have such a reasonable expectation, it is once again in accordance with the law and necessary to protect the procedural rights of the bereaved families under Article 2 and proportionate for their names to appear unredacted in the disclosure to core participants. Category 3, a person suspected of involvement in the Omagh bombing but not charged, who has not been publicly named in media reporting or otherwise as having been investigated. So not publicly named. Our provisional view is that those in this category, on the basis of high authority, do have a reasonable expectation of privacy, but that it is nonetheless in accordance with the law and necessary to protect the procedural rights of the bereaved families under Article 2 and proportionate for their names to appear unredacted in the disclosure to core participants. So again, our provisional view, sir, is that the documents should not, when they go to core participants, be redacted to remove the names of persons falling into that third category. Category 4, a person suspected of involvement in a potentially linked incident, but not charged, who has not been publicly named in media reporting or otherwise as having been investigated. Again, our provisional view is that those in this category do have a reasonable expectation of privacy, but that again it is nonetheless in accordance with the law and necessary to protect the procedural rights of the bereaved families under Article 2 and proportionate for their names to appear unredacted in the disclosure to core participants. So we recognise that if our provisional view in relation to each of those categories is correct, that view must nonetheless yield if in any particular case a real and significant Article 2 issue is raised in respect of an individual suspect. Again, we emphasise that such arguments would have to be approached on a case-by-case basis, and the inquiry expects PSNI to be in a position to inform it of any such issue, any such specific Article 2 issue where, if ever, it arises. Again, we make clear that what is currently an issue is disclosure to core participants, all of whom have signed a confidentiality undertaking. So disclosure to core participants of the names of suspects. We repeat that the inquiry will have in place a process that addresses questioning by core participants and others in public pursuant to Rule 10 of the Inquiry Rules of 2006. That process will include any core participant identifying whether they propose to ask questions about and or display publicly a document that contains the name of a suspect and explain precisely why it is proposed to do that. At that stage, which the media will be invited to contribute to, given that Article 10 will be a highly relevant consideration, reflection can be given to whether the Article 8 balance has altered. And it's possible that at that stage it will be necessary to inform the individual suspect of what is proposed and seek any representations they wish to make about the issues. But the provisional view of counsel to the inquiry is that it is not necessary to do that as part of the process of making a decision about disclosure to core participants, which is what we are dealing with today. So can we, nearly finally, mention in this regard the issue of the confidentiality undertaking and connected matters. In addition to the confidentiality undertaking, in the event that you do not uphold the submissions of either HMG and or PSNI, consideration could be given to the making of a restriction order prohibiting at this stage the public revelation of the name of any junior official and or suspect. Any such order would inevitably have to be reviewed at the stage at which there was a proposal to make such information public, but would provide in the meantime a further layer of protection from the concerns expressed by HMG and PSNI. And so, sir, we invite submissions on that proposal, in particular from anyone who would disagree with it. So everyone will be pleased to hear that that is all we have to say at this stage on issues 1 and 2, although we predict, want to make further submissions tomorrow once we have heard from the core participants. And in terms of hearing from core participants, we will start that process. We expect after a short break, sir, hearing first from Fiona Fee, King's Counsel, on behalf of HMG. But before that, sir, may we invite you to rise for perhaps 20 minutes?
Could I just explore something before we do, Mr. Greenie?
Of course, sir.
I'd just like to tease out a little bit more about the import of the 4 categories you've identified in relation to suspects.
Yes.
In each of the 4 categories, which are set out on a class basis, you've identified that on a provisional view, you would consider that those in this category have a reasonable expectation of privacy. And that, of course, is the starting point as identified in the case law that you drew my attention to.
Yes.
But am I right in thinking that in each individual case, that legitimate starting point would have to be assessed to see whether it in fact applied to the suspect who was under consideration?
Absolutely, sir.
And so, albeit these categories are reflecting different classes of suspects, do you anticipate that in each and every case there will be an individual assessment carried out?
We do so, yes. Well, we're simply seeking at this stage to establish some broad principles that can guide disclosure so that it can go to the core participants as soon as possible. But so you are absolutely right. The authorities are clear that the legitimate expectation of privacy is no more than a starting point which can be displaced in the individual circumstances of a particular case. But as we've made plain, we for our own part struggle to identify how a person in respect of whom there has been reporting that they have been investigated on suspicion of involvement in the Omagh bombing could have a legitimate expectation of privacy in respect of the fact of the investigation.
Well, I suppose you would say that that might be one of the easier assessments to make.
We would.
But there may be some that are a little more difficult.
We quite agree. So you have in fact reminded me by what you asked me of something that perhaps I ought to have said earlier, which is this, that one of the reasons why we have sought to deal with the suspects issue in categories is because our judgment is that it is not appropriate, well, it is not necessary and not appropriate during the course of this hearing for individual suspects to be named, that we can deal with them on a category basis.
Yes, thank you. Well, we'll break at this stage and I'll then hear further submissions from those who wish to offer them. My plan is to invite counsel to address me from the desk nearest to the front of the room so that we don't have to engage in an exercise of speaking to each other across the room. And we'll hear, first of all, from Ms. Fee on behalf of the Secretary of State. Thank you.
Thank you, sir.
Ms. Fee, good afternoon.
Good afternoon.
I'd like to make an observation before we begin, please. This is, of course, the first opportunity for the inquiry to hear directly from counsel who appear for the core participants on substantive matters. And that being so, I was disappointed to receive written notes on behalf of the Secretary of State late yesterday afternoon, just as I was boarding a flight to attend these proceedings. Now, I should imagine that you were only instructed to prepare that note very recently. And if so, I would like to say that disappoints me in respect of the level of engagement with the inquiry which it implies. We are all likely to be spending a significant amount of our professional lives in each other's company, and I would hope that we can do so in a harmonious, constructive, and mutually respectful manner. But it does seem to me that those aspirations are unlikely to be easily achieved if core participants or their representatives engage with the inquiry in a manner which appears to demonstrate a lack of prioritisation or allows an impression to be gained of a disrespectful or disorganised attitude towards the work of the inquiry. So whilst it is obviously helpful to have written notes, if they're going to be submitted, they really have to be provided to the inquiry at a point which allows their benefit to be achieved. So I don't want to say anything more about that other than to make those observations, and I hope they'll be received with the intention that I have in mind.
Thank you very much, Chairman. Perhaps if I could speak to that, firstly, just introduce myself for the benefit of the rest of the room. My name is Fiona Fee, and I appear as Senior Counsel on behalf of the Secretary of State. My Junior Counsel, Leona Gillen, sits behind me, and my instructing solicitors, the Government Legal Department, are also in the room, assisted in this jurisdiction by their sister organisation, the Crown Solicitor's Office. And if I could say, first of all, I've listened very carefully to what has been said about the service of the Skelton argument yesterday, and particularly, Chairman, I'm grateful for the remarks which have been made in respect of that this afternoon, and it is helpful in illustrating to us the difficulties that the inquiry considers were caused by the service. And it's important that I first say at the outset that absolutely no discourtesy to the inquiry or to other core participants was intended in serving the document. And in fact, the intention was exactly the opposite. The note itself is a note of what I will say today, and it was hoped that it might be of assistance to those following along to have a written record to save the need to take extensive notes. To speak very briefly to the chronology of the application, the Senior Counsel to the inquiry is quite right to say that HMG was originally asked to make the application by the 14th of March. I understand that a request for an extension was then sent explaining the reasons why, and that was granted by the inquiry, extending the deadline to the 31st of March, and the application was then made by that date. There were submissions in response to the application which followed, which were very helpful, and then a most helpful note from Counsel to the inquiry was emailed about 5 o'clock last Wednesday, the 14th of May, and that was picked up on the morning of Thursday, the 15th of May. And that was very welcome, as it indicated to us which parts of the application the inquiry would be most assisted by more information on. And briefly going to that note, which is at tab 10 of the hearing bundle, the sections which are perhaps most relevant are at paragraphs 11 and paragraph 16A. So paragraph 11 indicates that Counsel to the inquiry will also invite HMG in its submissions to deal with the following points, and it sets out 2 points. One in relation to those junior civil servants who may have published the identity of their employer via social media, and secondly, some of those who were junior civil servants at the time of the creation of the documents but may now be members of the senior civil service, and questions are posed in relation to both of those relevant matters. And then similarly at paragraph 16, It's indicated that counsel to the inquiry considers that the described distinction between judicial review proceedings and the inquiry proceedings that is apparently relied upon will need to be explained in detail and justified by HMG at the hearing. So with that helpful indication, Chairman, the HMG was assisted with a guide effectively to what it needed to expand upon, and HMG obviously act on behalf of a large client group, but within 4 working days a document was produced seeking to address those points as fully as we could do, and we could have treated that as an internal speaking note, and I could have made those submissions today in oral evidence, and we felt, and I accept in light of what's been said, that it was misguided, but we felt that it might be helpful to provide a written note of what we intended to say in response to those queries which had been raised in the note dated the previous Wednesday. And certainly the intention was to try and provide a written record of what would be said, but we accept, Chairman, that that has not been helpful in the way that we had hoped it would be.
Well, I think one of the concerns is that maybe I read this incorrectly, but it does seem to me that some of what's set out in the skeleton argument is different from what was set out in the original application, or at least frames the points differently.
Certainly, Chairman, it's intended to, there's an overlap of content, and it's intended to make the same points but expanding on the areas where we understood that expansion was necessary. It does not, for example, contain a volume of new case law. It refers to the cases referenced in our initial application and in the submissions of other core participants. And I want to stress, Chairman, that we are genuinely dismayed that service of the document has caused consternation, and the fact that our attempts have had the opposite effect to that which was intended and hoped for is a matter of real and sincere regret, and is taken extremely seriously.
Well, that's kind of you to say, and I accept that, of course, entirely.
Okay, thank you, Chairman. If I could perhaps move on to the body of the submissions. The Secretary of State submits that the Chair of the Inquiry should exercise discretion to permit the redaction of the names of junior civil servants in respect of disclosed material from the Northern Ireland Office. And if I could summarise 3 reasons in relation to that. Firstly, the names of the junior civil servants themselves are not relevant to the work of the inquiry, given that they do not fulfil decision-making roles as those in the senior civil service do. While there has been judicial criticism of the practice of redacting the names of junior civil servants in the AIB case, both the first instance decision and in the Court of Appeal, it's very important to recognise that those observations relate to the very particular duty of candour that the government owes in judicial review proceedings, and I'll come on, Chairman, to why we say that matters. Secondly, the naming of junior civil servants would disproportionately interfere with their right to respect for private and family life, which is protected under Article 8 of the European Convention on Human Rights. There's an expectation that junior officials are entitled to a greater degree of privacy from personal exposure than would be the case for their senior civil service colleagues, and the disclosure of their names into the inquiry would undermine this expectation. Now, obviously, it's not being suggested, and I know counsel to the inquiry made this very clear, that the names would be withheld from the inquiry team. That's not what we're talking about, but beyond that. Finally, the naming of junior civil servants could materially increase or create a risk to life, which is protected under Article 2 of the ECHR, given that there are a number of sensitive implications of releasing the names of these junior civil servants. And a witness statement has been provided, dated the 31st of March 2025, which should be read in conjunction with these submissions and which makes many of the same points. To deal firstly with the argument that the names are not relevant to the work of the inquiry. The Secretary of State's position is that the names of junior civil servants aren't relevant to the work of the inquiry, and there is accordingly no basis for their disclosure. there's a distinction between the naming of junior civil servants and the senior civil service. Senior civil servants are public-facing and are likely to be known to be employees of the state. It's recognised that the names of the senior civil service will be relevant to the work of the inquiry, as these office holders have a greater degree of constitutional responsibility for decisions implementing government policy, such that it's traditionally been accepted that they may publicly be identified, and they can be, for example, called to answer questions before Parliament. We contrast that with the role of junior civil servants. They do not fill decision-making roles, and accountability for any advice or recommendation they may help with always rests with the senior civil service, and their names, therefore it is said, have no relevance to the work of the inquiry. None of the submissions served by the other core participants clearly articulate why it is asserted that the particular names of junior civil servants appearing in documents disclosed to the inquiry are relevant to the work of the inquiry. At its highest, it is suggested in the McBurney submissions, paragraphs 8 to 12, and the Fox Law submissions, paragraph 17a, that relevance rests upon whether the person was junior or senior. While it's understandable that the decision in IAB has been focused on in the application, and the Secretary of State in the initial application did specifically draw attention to that decision, it's important to be clear about what the case decided, and hopefully to help expand upon the questions that the Counsel to the Inquiry's note asked us to answer in that regard. The context in which the issue arose in those proceedings is important. The High Court and the Court of Appeal was considering the issue of the redactions of the names of junior civil servants in the context of judicial review proceedings. And I know that those judgments have been made available in November 23 and February 24. The underlying judicial review concerned, as you know, Chair, the making of regulations intended to facilitate the use by the Home Office of houses in multiple occupation for accommodating asylum seekers. Fundamentally differently to this inquiry, the Administrative Court was provided with redacted material only and was not aware of the names that lay beneath the redactions, which were then challenged by the claimants. And in the High Court, the court in the High Court upheld the claimants' objections and ruled that the unredacted material should be opened up. And I know, Chair, you've already heard some quotations from that judgment, but there are some important points at paragraphs 12 to 17, and if I could flag some of those for the benefit of those who perhaps haven't had an opportunity to read the judgment in full. It is indicated 2 points of context are material. The first is that it is well established that the duty of candour is an obligation of explanation rather than simply an obligation of disclosure. And it continues further down. The obligation exists to ensure that a defendant explains, whether by witness statements or the provision of documents or a combination of both, the reasoning process underlying the decision under challenge. In the present case, the Secretaries of State have to date chosen to discharge their candour obligation by disclosure of the documents in the 4 disclosure bundles. No witness statements have been provided. And the second point of context is the criterion for disclosure of documents in judicial review proceedings. The standard applied by the court when asked to decide whether disclosure of a document is required is whether disclosure is necessary for the fair and just determination of an issue in the case. And it cites case law in respect of that. And that perhaps is a helpful paragraph, Chairman, in outlining that the duty of candour in judicial review arises in the context of a very different discovery process. The state can, in a judicial review, choose to discharge their candour obligation by disclosing documents, or they may not disclose documents. They may disclose a witness statement, or they may disclose both. The core of the obligation of the duty of candour is an obligation of explanation, and we say that makes sense in the context of judicial review proceedings, but does not apply in the same way to a public inquiry, which does not have the same disclosure processes. At paragraph 13, the judgment continues. It follows that the correct premise is that by making the disclosure they have already made, the Secretaries of State accept that disclosure of those documents is necessary for the fair and just disposal of the issues in this case. Or at least, per Lord Bingham at paragraph 4 of his speech in Tweed, that the disclosed documents are significant to its decision. In this case, the documents disclosed, which evidence the decision-making process, were no doubt disclosed in support of the Secretary of State's response to particular challenges which were raised in that case. And again, Chairman, we say that that indicates the different nature of the position in judicial review, where the documents which are being disclosed, each of those documents is considered to be significant to the decision. A judicial review doesn't capture the same breadth of documents that a public inquiry will. It is a very focused exercise on those documents which are significant to the decision and which evidence the decision-making process. So we're not talking about the same kind of documents in a judicial review as compared to a public inquiry. And picking up the judgment again, Chairman, at paragraph 14, it indicates the practice of redacting, of blanking out parts of documents disclosed in litigation on the ground that the part redacted is irrelevant is long established. One obvious situation is where a part of a disclosable document does not concern the subject matter of the litigation. And the judgment goes on to provide a quotation from Lord Justice Hoffman in the GE Capital Corporate Finance case, in which he said, "In my view, the test for whether on discovery part of a document can be withheld on grounds of irrelevance is simply whether that part is irrelevant. There is no additional requirement that the part must deal with an entirely different subject matter than the rest." And the last sentence of that quotation is perhaps important. "Provided that the irrelevant part can be covered without destroying the sense of the rest or making it misleading, a party is permitted to do so." And the court considered that quotation from Lord Justice Hoffman, and at paragraph 17, the court indicated that the judge did not consider the correct approach to redaction of disclosed documents in judicial review pleadings can be driven only by the purity of Lord Justice Hoffman's logic. What is required to discharge the obligation of candour when a public authority chooses to meet that obligation by disclosure of documents must, at the least, be fully informed by the purpose of the candour obligation. Redaction, sentence by sentence or line by line, as a matter of course, runs against the grain of an obligation aimed at ensuring public authorities responding to judicial review claims should explain the reasoning underlying the decision under challenge. And again, Chairman, we say that all of that speaks to what the duty of candour is in judicial review, and it's a duty to explain. At paragraph 20 of the judgment, the judge made further specific observations about the duty of candour, and he noted that an approach to compliance with the obligation of candour that as a matter of routine hides detail that assists the court's understanding of the public authority defendant's explanation of the decision under challenge is antithetical to the purpose of the candour obligation. And again, it's focused on the explanation of the decision under challenge, because that is what those documents in the judicial review cases are directed at. The judge considered that this was an issue of importance in terms of practice and procedure, and the case went to the Court of Appeal. The Court of Appeal similarly discussed the nature of the duty of candour, and in that Court of Appeal judgment...
Of course, in paragraph 17 of the decision that you're discussing with me, the first instance judge expressly accepted that the outcome of the grounds of challenge don't depend on the identity of the decision maker or of any other person involved in the decision-making process.
Yes, absolutely.
So why then would those names not fall to be redacted?
So my interpretation of the decision, Chairman, is that in a judicial review case where the Secretary of State or anybody else has chosen and has taken a view that the best way to discharge their duty of candour to explain the documents is to provide particular documents which are relevant to the making of the decision. So those are key documents, important documents, and they go to evidencing the decision-making process, that all of the judge's comments are to be viewed through that lens. And we say that is different from a situation where, in a public inquiry, inevitably, and rightly so, in the performance of its duties, the inquiry will gather a very large volume of material, exponentially greater than a judicial review court might expect to gather. And not...
Isn't it,
sorry, Chair.
Isn't it at heart undertaking a similar function, namely looking for the explanation?
If the documents that it's looking at go to an explanation for the decision under challenge, we can expect that that might be submissions to the Minister, key emails, those kind of documents. And that is different from in a public inquiry where one might gather up lots of relatively innocuous emails which don't touch on the Omagh bomb specifically, which don't touch on any matter which is key to the heart of the inquiry. And it's whether the legal framework and the obligations in one context, the judicial review context and IAB, whether they can readily and straightforwardly be read across into a public inquiry, which is doing a different function. It isn't asking the state, what documents do you say go to the decision-making process? Please provide them. It's saying, here are our terms of reference, here's our list of provisional list of issues, cast a wide net, and that's
Sure.
appropriate.
But once the material provider has done that, then the inquiry legal team assess those documents for actual relevance.
Yes, certainly, Chairman. And at that
It's
stage...
only those documents that have actual relevance that will then be circulated to core participants.
Yes, I think it's conceivable that a document could be actually relevant, but not significant in the sense that the documents in AIB were significant for the decision-making process. It will depend how much disclosure the inquiry legal team ultimately determine to be actually relevant, but it would perhaps be understandable if that turned out to be a large volume of material directed at many different parts of the terms of reference or list of issues. And that's, in a nutshell, Chairman, why we say that the categories of document aren't the same and the analysis can't be exactly the same. In relation to what the Court of Appeal said about the duty of candour, I'm at paragraph 12 of the speaking note, if that assists. The judgment of the court at paragraph 24 of the Court of Appeal decision indicated that the court did not accept that decisions such as GE Capital, which I referred to earlier, provide any basis for saying that documents in judicial review cases may be routinely redacted to remove names, or indeed taking counsel for the state's arguments to their logical conclusion, any other detail not directly relevant to the outcome of the dispute. Ordinary civil litigation is very different from proceedings in the administrative court. There is no duty of candour equivalent to that imposed on public bodies defending judicial review claims. Instead, there is a duty to disclose documents. And it goes on to talk about standard disclosure under the CPR. We, of course, don't have the CPR in Northern Ireland, but we have our own disclosure rules. And the point which is made in that paragraph that there is a duty to disclose documents in certain kinds of cases, and then in a special category of case in judicial review, you don't have that duty to disclose documents in the same way. You have this duty of candour, which includes within it an obligation to explain, and the way that you do that will be documents, witness statements, or both. And the Court of Appeal goes on to consider situations.
What the Court of Appeal is saying there really is that in judicial review cases, the duty of disclosure, which is informed by an associated duty of candour, is different from and is wider than that which applies in ordinary civil litigation. Is that right?
I think it's the language used is very different from proceedings in the administrative court, and I think we respectfully agree with the Court of Appeal in that assessment, that it's quite a different context.
But inquiry proceedings are very different from anything that happens in the administrative court as well.
They are. It's a different category of proceeding, and when directly applying the reasoning in AIB in that specific context to a public inquiry, I think what we suggest is that the two don't necessarily engage all of the same concerns for the reasons that I've outlined in relation to the kinds of documents that are caught and the different nature of the obligation. In a judicial review, you're going through the documents and selecting those which are important to discharge the duty of candour and to make sure that the explanation of the decision under challenge is full and comprehensive for the court. And that's really not the exercise that we're doing in a public inquiry, where, as I say, casting a wide net, looking at the terms of reference, looking at the provisional list of issues, and funneling all of that much broader suite of documentation through to the inquiry team.
I suppose some people would say that the reason you cast that net widely in the context of inquiry proceedings is because of the essential function of the inquiry, which is to establish the facts and to establish the truth of what happened and to ensure that lessons can be learned. And with that process at its heart, you might be inclined to think that the duty of candour was even more intense in inquiry proceedings than in any other form of proceedings.
Well, I think, Chairman...
Well, they're inquisitorial, they're not adversarial. Even judicial review is adversarial.
I think Chairman is quite right that has to be why the net is wider in a public inquiry, because of its purpose, because of its truth-seeking role. I think all of that has to be correct. The question is, what does that mean in terms of the classical duty of candour as described in judicial review proceedings? So the discovery process is different, so the duty cannot apply in exactly the same way, but that does not mean that the state is not under a duty to be candid in an inquiry. Of course it is under a duty to be candid, but that doesn't mean that the legal duty of candour, looking at the documents, working out which ones speak to the decision at hand, and deciding whether to do it by way of a witness statement, documents and so on, it doesn't mean that all of that methodology follows across, and therefore we say the reasoning requires perhaps a little more thought, and that's what we've tried to do in the written submissions and in these oral submissions. If I could pick up, Chairman, at paragraph 13 of the speaking note, which deals with paragraph 29 of the Court of Appeal decision. That's where the court felt that there were situations in which it would be entirely appropriate to redact names. It says, for example, for reasons of national security or where there is evidence of a real risk to the personal safety of the individual concerned. And the judicial review proceedings, paragraphs 14 to perhaps 21 of the speaking note are directed at the kinds of matters we've just been discussing. Chairman, I won't go through all of that in detail, but at paragraph 15, we note that judicial review proceedings are concerned with the lawfulness of specific decisions made by public bodies, and they operate as a facet of upholding the rule of law. In judicial review proceedings, it's for a public body to provide an explanation of the particular decision under challenge so the court can see clearly whether there's been an error of law in that decision-making process. And the administrative court guide highlights that self-policing, explains why. And as the court observed in the AIB cases, The position is different from civil litigation for the reasons that we've canvassed. And I think it's important to reiterate that this is not a situation in which it's proposed to withhold the names from the chair or the inquiry legal team. And that is, we say, an important point of distinction compared to IAB. In IAB, the court was operating entirely blind in respect of the redactions, and that resulted in practical challenges. And we can see that thread running through the Court of Appeal's reasoning. In this inquiry, in contrast, the inquiry legal team will be well equipped to assess the relevance and significance of documents as they undertake their review and as the work of the inquiry progresses. So if, in any particular case, they identify that the junior civil service name might be relevant, that could be addressed at that stage. But in circumstances where no reasons have been identified why the specific names themselves are relevant to the work of the inquiry, it's submitted that there is good reason to redact those names, both from disclosure to the court participants and, in due course, from the public. Paragraph 8 of the Fox Law submissions touches on this point, acknowledging that IAB rose in the context of judicial review, but it goes on to draw an analogy between disclosure in public inquiries and ordinary civil proceedings, which we take to include judicial review in this context on the Fox Law submissions, relying on a COVID inquiry decision. And our submission is that paragraph 66 of that decision only offers weak support, and the paragraph is set out in full in our speaking note, but it does contain the sentence, it simply means that irrelevant documents may be redacted. It was common ground that the analogy with civil proceedings could only be a loose one because there were different rules applying for civil proceedings, and civil proceedings pursue a different aim to public inquiries. And it goes on to say, but it would be surprising if a valid request in civil proceedings made under the former rules of the Supreme Court might yield irrelevant documents and still be lawful, but such a request by an inquiry acting under a statutory power permitting requests for documents would be unlawful. The citation also in the Fox Law submissions of the Amin case, we say, does not encapsulate the correct principle, which we say is to be found at paragraph 20 sub 8 of that decision, where it is said that public scrutiny of an investigation cannot be regarded as an automatic requirement, and that the degree of public scrutiny required may well vary from case to case. So in summary, the judgments in IAB are relevant to judicial review proceedings, where that very special duty of candour arises with particular disclosure consequences. We contrast that with a situation where it can be said that the names of junior civil servants are not, in general, relevant to the issues being investigated by the inquiry. Whether a junior civil servant is named John Smith or Jane Doe, what their email address is and what their contact information is, generally can be of no relevance to the matters under consideration by the inquiry, and we say can properly be withheld from disclosure to court participants or in due course to the public. With your permission, Chair, if I might move to the question of the naming of junior civil servants disproportionately interfering with their rights under Article 8 of the ECHR. The inquiry is a public body for the purpose...
Can I just ask you one thing before we move on?
Yes, certainly,
to that?
Chair.
One of the issues which was canvassed, certainly to some extent in the first instance IAB decision, and I think also in the Court of Appeal, was the issue of the practical consequence of redaction.
Yes, Chair.
And at paragraph 18 in the first instance decision, redaction leads to significant practical difficulties. And it talks about how most decisions made within government involve significantly sized groups of civil servants. Some are spread across different departments. Redacting names makes the decision-making process and the significance of each document disclosed more difficult to understand. And when correspondence and other documents are disclosed for the purpose of evidencing a decision-making process, it will rarely be the case that it will not assist the court's understanding of that process and the decision itself to know by whom or to whom the documents were sent, forwarded or copied. In most cases, when this information is redacted, any outsider's understanding of the documents is significantly hampered. So there's a sort of intelligibility point that's canvassed, at least in the first instance decision in IAB. Does that arise here?
No, Chairman, I think that's an important point, and it runs through the IAB decisions and also the FM Holdings case as well, which Senior Counsel to the Inquiry referred to. It's a thread that runs through those decisions that you can render a document meaningless and unintelligible by having large sections of the document blacked out. And I think that's familiar territory in terms of public interest immunity applications and all kinds of other redaction exercises. The documents have to be intelligible, and that remains the case here. But where we have, for example, an email, the provenance of which is clear by the fact that, for example, it goes from one senior civil servant to another, and thus those names are not redacted. But you have a copy list which includes 10 junior civil servants who were copied in, perhaps in some cases for admin reasons, filing reasons, and so on. We say, doesn't affect the intelligibility of the document in any way whatsoever. And in one sense, it might actually make the document easier to understand because you've removed a large chunk of totally irrelevant information, and the reader has the relevant information available to him or her. And the check on all of that, Chairman, in this context is that, totally unlike in the IAB situation, the inquiry has full sight of the unredacted documentation.
Yes. All right. Thank you.
So, Chair, if I could move on to the Article 8 point that I had referred to previously. The inquiry is a public body for the purposes of the Human Rights Act 1998, and accordingly it's unlawful to act in a way which is incompatible with convention rights pursuant to Section 6 of the HRA. And Article 8 requires that there shall be no interference by a public authority with the right of an individual to respect for his private and family life, his home and his correspondence. The Omagh bombing, as I know, Chairman, you're acutely aware, was an incident of particular notoriety, and the description of it by Mr. Justice Horner in the judicial review proceedings which preceded this inquiry was of a terrible atrocity, the worst in the last 60 years of Northern Ireland's history. And it's against that background that the Article 8 ECHR rights and those protected by Article 2 of the civil servants are engaged and require safeguarding through proportionate measures. And I won't dwell on this, as I know, Chair, you're well aware of the position under Article 8, but where a decision has been taken that interferes with a person's Article 8 rights, it's necessary to carry out an assessment of proportionality, which involves considering, is the aim sufficiently important to justify interference with a fundamental right? Is there a rational connection between the means chosen and the aim in view? Was there a less intrusive measure which could have been used without compromising the achievement of that aim? And has a fair balance been struck between the rights of the individual and the general public interest? We set out at paragraph 25 of the speaking note where that four-stage test has evolved from in the case law. Proportionality in this context requires an examination of the relevance and significance of the information in contemplation, which is the names of junior civil servants, open justice as it pertains to that information, and balancing that against the interference with the individual's family and private life. It's respectfully submitted that in circumstances in which, firstly, the inquiry will be provided with the unredacted material, and so will be able to see the names, and secondly, in general, the particular name of a civil servant will add nothing to the substance of the material provided, there is little to balance on the side of open justice. Whether Joe Bloggs was copied into an email doesn't advance anyone's understanding of the issues the inquiry is investigating, but his identification as an employee of the state could interfere with his private and family life by undermining the confidentiality which is applied to his role and his place of employment. Identification as an employee of the state has a specific significance in Northern Ireland. Northern Ireland continues to grapple with the legacy of armed conflict and the dissident threat, and we say there are considerations in play, as I'll go on to explain, which do not necessarily arise in other jurisdictions and in other contexts. The specific risk of dissident republicanism, particularly against those employed by the state, has long been recognised by the courts. Bearing in mind that the vast majority of the information relevant to this inquiry was generated during the Troubles, in a time prior to the current legal landscape of legacy litigation and public inquiries, junior civil servants had and continue to have a reasonable expectation of privacy in respect of their work.
Can we just pause there? I've got a sense that there's becoming an intermingling of risk and Article 8 privacy issues here. It's one thing to say that someone has an Article 8 right to private and family life, but it's quite a different thing to say that they're subject to a particular risk. I mean, that might engage Article 2 or Article 3. But I'd like just to be clear about what you're saying in relation to Article 8.
Yes.
Are you saying that the fact of a person's employment as a junior civil servant is something that falls within the protection of the Article 8 rights to private and family life?
Yes, Chairman, when we talk about a reasonable expectation of privacy, and does an individual have that reasonable expectation of privacy, we say that it is relevant to consider the context in which they are working. And an individual working on sensitive matters in Northern Ireland, who does not wish to be identified as an employee of the state, and who perhaps has never told anybody beyond their very immediate family members that they are an employee of the state, that is relevant to their expectation of privacy, we say. And
but where does that come from? Is that something to do with their employment, or is it something to do with Article 8?
so it's the question which is part of the Article 8 analysis or assessment, in terms of whether that person has a reasonable expectation of privacy. We say it goes to that. It isn't simply an Article 2 and Article 3 point.
Well, is there any authority to support the proposition that the fact of someone's employment is something that's protected within the Article 8 right to family and private life?
I think not set out in the speaking note, Chairman. I think the point that is made therein is that when you are considering whether an individual has an expectation of privacy, there are various factors which might be considered, and one of those factors in a Northern Ireland context should appropriately be the concerns about being identified as an employee of the state. And
But what are those concerns?
well,
They're presumably concerns of some sort of social disapproval or worse.
yes, Chair.
So that's not Article 8, that's something different.
Well, I think, Chairman, our submission is that it is part of the reasonable expectation of privacy, and therefore it is part of Article 8.
But Article 8 doesn't just state that you have a reasonable expectation of privacy. Article 8 relates to private life and family life. Now, that's why the question arises. Does the fact of employment fall within Article 8, or does the fact of employment within the Northern Ireland office arise as a consideration in respect of some other matter? And the reason I ask you, of course, is because of what's said in paragraph 25 in the IAB first instance judgment, which says that there's no general expectation of privacy or confidentiality in the fact of a civil servant's employment as a matter of general employment law. And it says, moreover, when at work, civil servants are not involved in anything that can be described as a private activity. They are exercising public functions as part of the public service of the country. Now that, I would read as a statement that's completely contrary to the proposition that someone's employment as a civil servant would fall as a protected aspect of Article 8. I recognise entirely that the question of risk is different and might arise in respect of civil servants, but that would have to be looked at differently.
And I think the distinction that we're drawing, Chair, is that there are considerations in a post-conflict society in Northern Ireland that don't necessarily arise in other situations, but I won't labour the point. That's the submission that we make, I think, in both the speaking note and orally today, and in particular at paragraph 29 of that speaking note, we highlight that this has been recognised by the courts in Northern Ireland, including the Courts of Appeal, that it's been recognised that employees of the state may not have been open in disclosing their employer even to their family and friends, and their reasons for that reticence about being publicly identified as an employee of the state shouldn't lightly be ignored.
Well, do I have this case?
That should be, Chairman, there should be 2 bundles in front of you.
Is it this one? Okay.
And this is the Re-C case, Chairman. So it starts at page 400 of the bundle, which is folder 2. It's one of the cases which arose from the inquest, judicial review, Jordan matter, and we've highlighted in the copy that's on your desk, Chair, we've highlighted some key passages, and those are highlighted in yellow, and they appear at pages 425 and 428, 429, and I believe that's the totality. And I accept, Chairman, that overlaps with the question that you asked me about Article 2, because this judgment engages in some detail with the issue of risk and the Article 2 context, and it's largely against that background.
This concerns the shooting of a young man by police officers and the giving of evidence to an inquiry by serving and former police officers.
Yes, Chairman.
In respect of whom there was an evaluation of risk.
Yes, Chairman.
So where's the Article 8 point?
I think the reason that is referred to, Chair, is to indicate that when we say that employees may not have been open in disclosing their employer to family and friends, it's not a new submission. It's a point that's been made before in a variety of species of litigation throughout Northern Ireland, that there's a cadre of individuals who were, at the time of the events relevant to this inquiry, and even today, very reluctant to be identified as employees of the state, and that just may be slightly different from some other jurisdictions.
Okay. And what about those who, according to Mr. Greenie, have publish their employment information on social media?
Yes, Chairman, and we've, I think, tried to deal with that question at paragraph 33 of our speaking notes. And what we say about that is that the Secretary of State's position is it makes no difference to the merits of the application that some junior civil servants may have chosen to publicise their identity on the internet, and that fact can't have a bearing on the Article 8 ECHR rights and expectation of privacy, which applies to other civil servants who haven't taken such steps. And similarly, while I'm on that point, on the fact that some junior civil servants might have later held civil servant roles at a higher level, senior civil service roles, that also doesn't affect the general application. And both scenarios, we say, can be addressed on a case-by-case basis if and to the extent that the inquiry team identifies any junior servant names which are relevant or already in the public domain, and they could be in the public domain either because of their own actions, such, Chair, as you've mentioned, by social media, or because they later took on a senior role. And we say that junior civil servants, particularly in the time frame relevant to the public inquiry, had a reasonable expectation of privacy, but were pragmatic about the names of the senior civil servants who were often more public-facing. But in respect of junior civil servants, we say it is relevant. They may not have been open about their employer, even to family and friends, and that when there is no relevance to their identity, that the balance should tip in favour of protecting their Article 8 rights. And then, Chair, in relation to the point that you'd asked me about earlier, in Article 2 of the ECHR, what we say about that starts at paragraph 34 of the speaking notes. And as is identified in our original application, there may be some junior civil servants, for example, those working in defence or security roles, for whom the risks to their safety may be of a different character. And Article 2 ECHR requires that everyone's right to life should be protected by law, and there's an operational duty on the state, or in this case the inquiry, to safeguard the lives of those within its jurisdiction. And we have set out at paragraph 35 some cases which again will be in the bundle before you, Chairman. Lord Carswell's conclusions in Re Officer L.
But this is all about anonymity again. We're not at this stage talking about publishing. We're just talking about disclosure to core participants who've signed a confidentiality agreement.
Yes, Chairman. And I think what we've tried to do in the submissions is set out firstly the general position, and then where there are more specific concerns to highlight that. But I think as a matter of general principle, whether these names should go out to, should go beyond the inquiry effectively is the key issue on the part of the Secretary of State.
Well, that might well be a matter of general principle, but it's not going to be determined by general principles that apply to publication.
I think, Chairman, it may be that if we are, I think as has been flagged earlier today, potentially having it may be that there's a further hearing at a later point which deals with disclosure on to the public, depending on the outcome of this hearing. It may be that these cases may be more acutely relevant at that stage, and
yes,
certainly rather than taking you to those cases and into the bundle at this stage, simply going to refer to them in general terms and to indicate that they have given consideration to this question about issues around giving evidence without anonymity and what potential risks that might have. Obviously, disclosure beyond the inquiry, the wider the pool of disclosure, the harder it is to control the flow of information. And I know that's a concern often expressed, for example, in commercial court contexts around confidentiality rings and so on. We set out a paragraph 36 some of the context around dissident Republican groups and the unfortunate reality that they're actively planning and carrying out attacks, including on members of the security forces and those employed by the states. Identification of a junior civil servant through a document, however innocuous, could assist with targeting more readily. And this not only increases the actual risk towards junior civil servants, but it's also likely to increase their subjective fears. And we've set out a quotation in relation to that from the Re Officer L case. And as I've said, I don't propose to take you in detail, Chair, to any of those cases unless it would be of specific assistance. In Re C, we saw the court drawing a clear distinction between a retrospective analysis of the sort that would be undertaken in an Osman type situation and the prospective risk assessment task undertaken by the court in cases considering the need for operational measures to protect life. The Omagh Bombing Inquiry involves material generated during the Troubles and touching on the atrocities of dissident Republican groups, many of which are, unfortunately, still in operation. We say this cannot reasonably be compared to IAB in respect of expectation of privacy and potential engagement of Article 2 ECHR. And for the reasons which we've already given, the risk is heightened for those working in defence roles, and that is also addressed to an extent in one of the cases that Senior Counsel to the Inquiry mentioned earlier, the FM Holdings case. The open availability of staff names, email addresses and their roles increases the information available to these hostile groups, and it enables improved intelligence and targeting information to be obtained by such organisations, which would be of considerable value to a hostile actor. So in conclusion, Chairman, the application does not advance some general principle of redaction absent good reason, which was the problem in IAB, as the court found. Irrelevance is fundamentally a good reason to redact the material, particularly in circumstances where convention rights are engaged. Article 2 and Article 8 are good reasons to redact and frequently cited in Northern Ireland legacy and indeed modern cases to protect those working for security forces in the state. And the inquiry, we say, is also entitled to take into account the practical difficulties of the very substantial disclosure exercise it's carrying out. Dealing with the redaction of junior civil servant names on a case-by-case basis will be burdensome and time-consuming and disproportionate to any benefit in terms of open justice, which it is submitted will be negligible. It will lead to potentially unnecessary increased costs, and we say that those sorts of practicalities are matters to which the inquiry, if it wishes, can give consideration. Unless there's anything further, Chairman, that was all that I had intended to say on those matters.
Thank you, Ms. Fee.
Thank you very much, Chairman.
So we're next going to hear submissions of counsel for the Police Service of Northern Ireland, Philip Henry, King's Counsel. We've been sitting for 58 minutes. Mr. Henry has told me that he anticipates that he will be no more than 30 minutes. It is desirable that we should hear both applications, if that is what they are, before lunch so that they can be reflected upon by other core participants. But could I check first of all with those who are helping with the transcript? Thank you. And then check with you whether you are content to sit beyond what would be the normal time for breaking for lunch.
Yes, I certainly am. Is Mr. Henry content to speak at
I
this
ought to
stage?
check with him as well.
Yes.
Thank you very much.
Oh, good afternoon, Mr. Henry.
Good afternoon, sir. As you've heard already, my name is Philip Henry. I appear on behalf of the PSNI, and I'm assisted today by Ms. Kelly and Mr. McCartan, Junior Counsel. So hopefully, sir, you will have received our written submission. I'm not going to read through that this afternoon. I thought what I'd do is highlight some key issues, and if you wish me to develop those any further, I'd be happy to do so.
Yes.
In terms of the points that I was going to raise with you, sir, I would make some general observations at the beginning. I'd explain briefly what position the PSNI normally take whenever it is the decision maker. I'd I'll deal with the reasonable expectation point, which generates the Article 8 right, or is the threshold which applies to determine whether or not it's engaged or not, and then go on to deal with the Article 8.2 qualification point. But I think it might be useful just at the very outset, sir, to answer the question that was posed to me by Inquiry Counsel. Is the PSNI position that it's applying for redaction of the suspects' names, or is the PSNI's position that it's flagging up these issues so that the inquiry can make an informed determination on the redaction issue? And it's firmly the latter, sir. We haven't lodged an application with you. That was a conscious decision, but we did want the inquiry to be as informed as possible, so that whenever it was making any decision on redaction of suspect names, it had the legal principles before it. That issue, if you like, and I think it might be helpful for some of the other core participants to know this, but the issue developed during the course of constructive dialogue, ongoing dialogue between the PSNI legal team and your own legal team. And we simply put on the radar, as it were, that this is something which the PSNI have to consider whenever it's dealing with suspects who were arrested, interviewed and released without charge. We do, however, at the outset, sir, recognise that the inquiry is in quite a different position, and that there are a set of proceedings in place which are not in place in the PSNI context. What we've tried to do in our position paper or speaking note is set out the relevant legal principles. We did that in an attempt to be helpful to the inquiry. We hope that it's been received in that spirit. And I wouldn't want there to be a misperception that we were attempting to reduce the amount of information unduly which was being released to the other core participants. We were simply trying to provide the court, or the inquiry, I beg your pardon, with as much information as we could in relation to the legal principles, so that its decision is as informed as possible. I would also make the general observation that what we're dealing with here, and it's something which Mr. Greenie touched upon earlier, and indeed formed one of the exchanges between you, sir, and Mr. Greenie. We're really dealing with these issues at the moment almost in the abstract, in general terms, necessarily so because we're not going into the detail of individual cases. That does make it a little bit more difficult for you, sir, in terms of making a determination on a general approach, but it is, I respectfully suggest, still quite helpful to have the discussion in general terms, because as we've said, it does identify the principles that you'll have to apply. So in terms of the Article 8 position.
Mr. Henry, can I just ask you, you're a little taller than Ms. Fee, and I maybe need you to adjust the microphone a little bit.
Certainly. Is that any better, sir?
It's much better, thank you.
And if that happens again, by all means, sir, draw it to my attention. So in relation to the Article 8 positions, obviously the first question that you have to consider is the suspect's Article 8 right engaged, or one of the Article 8 rights engaged. I think we can narrow this discussion down a little bit. If the individual has been charged with a criminal offence, their name goes on to a public court list, save in very exceptional circumstances, and that reasonable expectation of privacy evaporates effectively at that stage. It no longer exists. So the cohort of individuals that we're dealing with at the moment during this discussion is simply those who were not and have not been charged with any criminal offence.
And there has been, of course, some civil litigation as well.
Well, it's something I was going to touch upon, and how that impacts on the reasonable expectation of privacy. I'll maybe come to that in just a moment, if I may. But I did want to set, I thought just for the benefit of those who perhaps haven't read through the position paper that the PSNI submitted, it might be helpful in very basic terms for the PSNI to set out what it does. So if there is an individual who's taken into, or who's deemed to be a suspect and is arrested and is released without charge, the PSNI's starting position, in line with the decision of Richards and ultimately Bloomberg from the Supreme Court, the starting point is that there's a reasonable expectation that their designation as a suspect in a criminal investigation that did not result in a charge and did not result in criminal proceedings, the starting point is that they have a reasonable expectation of privacy, and that information should not be made public. So their name should not be attached to that process. The PSNI rarely deviates from that starting position because it's fairly well established. But as Mr. Greeny's opening to you has already identified, it's not a universal rule. It doesn't have hard and fast application, and there can be deviation from it in certain circumstances. One of the things that you will have to consider is what effect does the existence of the inquiry per se, and then the duties on the inquiry have in relation to that reasonable expectation of privacy. I would just draw, before I move on to talk about the reasonable expectation of privacy in a little bit more detail, just draw to your attention one perhaps minor distinction. There is a distinction between the alleged offending on the one hand and an individual's designation as a suspect on the other. I'm not quite sure if I'm going to be able to assist you any further in relation to what the significance of that distinction is, but it is something that we respectfully flag up for you to consider, because it's something which the PSNI, in its typical scenario, has to consider. And I raise that because it has been touched upon in some of the core participants' written submissions, where there's a focus on the offending, and the point that we had raised with the inquiry was the designation of someone as a suspect who has not been charged. And so we say there's a degree of distinction between those two.
So are you thinking there about what the definition of a suspect is?
Yes, well, it may be an immaterial distinction, because if there were clear evidence on the one hand of someone's involvement in offending, you're unlikely to arrive at a situation where they're not charged with the offence. So it is conceivable, but it's difficult to think of an example. So as I say, the distinction between the 2 points might be immaterial, but it's something that I wanted to place on the inquiry's radar so that it could consider whether it had any impact at all. Returning to this issue then, sir, of the reasonable expectation of privacy. So that's our starting point for the decision that has to be made. If it exists, and there's an interference with it, then one moves on to the qualification provision in Article 8.2. But if there is no reasonable expectation of privacy, you don't need to progress to stage 2 and consider the lawfulness of any interference and whether that's in keeping with that qualification. And one of the things that's helpfully been set out in the inquiry legal team's position paper is what effect someone's involvement or alleged involvement in previous offending being in the public domain has in relation to the expectation of, or reasonable expectation of privacy. That's a reasonably simple proposition, relatively easy to understand. If it's already in the public domain, then you can't have, or you're much less likely to have, a reasonable expectation of privacy. Whether something, and this is the point that I'm respectfully asking the inquiry to consider, and in keeping with all of the observations I'm going to make this afternoon, sir, these are not The PSNI is not adopting a position, as it were. We're simply asking or presenting these points for consideration so that you have that information in an attempt to be helpful. Is something in the public domain? The examples that Mr. Greene mentioned earlier, the first is reference in Hansard or Parliament, and the second was reference in a newspaper article or some other media publication. So you might consider that whether something exists in the public domain is a question of fact and degree. There'll be different subjective views in relation to that. Ultimately, you may feel that you have to reach an objective determination in relation to that. Is it in fact in the public domain? Two extreme examples at opposite ends of the spectrum would be something that we talked about a moment ago. So if someone is a defendant in related civil proceedings, such as the Breslin proceedings, and they had not been charged, there is a significant amount of public exposure already clearly associating that individual with the Omagh bombing. In that situation, the decision might be relatively straightforward. The public domain decision and therefore the reasonable expectation of privacy decision. At the other end of the spectrum, you might have a situation where someone has been named in association with one incident, and it may fall into the category of the 31 previous incidents that are currently being explored. And that incident may or may not ultimately be, in the opinion of the inquiry, linked to the Omagh bomb in some way. And so with those two extreme examples, and I present those to you just by way of illustration, to respectfully suggest that whether something is in the public domain or not may not just be a straightforward decision, but ultimately it will require an individualized decision, I think, in relation to each of the suspects who fall into this cohort. Perhaps less importantly so, but still something you may wish to consider, sir, is whatever reference has been made to that individual in the public domain, what incident is it referring to? So is it referring to Omagh, the Omagh bombing? If so, in the context of this inquiry about the Omagh bombing, they're much less likely to have a reasonable expectation of privacy. The further that one moves away from the Omagh bombing incident itself, the greater argument the suspect may have in relation to a reasonable expectation of privacy. And the inquiry at this stage...
I wonder why that would be so. If someone is identified as a suspect in relation to one of the linked incidents, why would they have any greater expectation of privacy in respect of that matter than somebody would have who was identified as a suspect in relation to the Omagh bombing?
Well, it's a fair question, sir. You describe it as a linked incident, and I've been referring to it as a previous incident. And in due course, the inquiry will have to make a factual determination in relation to how, or first of all, whether there's an association between the two. And the point that I'm respectfully making is that it may ultimately be, at the end of that process, you make a determination that some of those previous incidents do bear a relationship with Omagh, and some do not. And if the individual...
I see that very clearly. But I'm just wondering about what impact that has at this stage when we're only talking about disclosure to CPs.
Well, there's a couple of aspects to it. First is it's the limited disclosure, as it were, or publication only to the CPs. And the second point that the inquiry might wish to consider is if the exploration in relation to the 31 incidents at this stage is a legitimate, rational exploration based on sound judgment. If the individual is associated with that linked incident and you have a bona fide good faith reason for exploring that incident, that may provide the inquiry with a greater degree of comfort in relation to finding that there is not a reasonable expectation of privacy with them being named in the Omagh Bombing Inquiry if the only link is to that single previous incident. But it's the reason I'm drawing this to your attention is just so that the greatest degree of thought possible is brought to the process rather than jump straight into cohorts and classifications. How one builds those cohorts of falling it into one category or another may be as important a process as the identification of the cohort itself. Final observation I'd make in relation to this issue, sir, is that whether the public reference was previous civil proceedings, a reference in Parliament, or a reference in the media, you may wish to consider the detail of that reference as well.
What, sorry?
You may wish to consider the detail of what is said about the individual in connection with the incident. It's a little difficult to speak about that without a concrete example in front of us, sir, but it may be a fleeting reference based on very little information, or it may be a detailed exploration, such as in the civil proceedings, with reference to evidence and potentially linking an individual to offending. Those are two opposite ends of the spectrum, and that may be something that you wish to consider when making a determination as to whether their name is in the public domain in connection with the Omagh bombing, and therefore, thereafter, I should say, whether they have a reasonable expectation of privacy or not. I think, sir, once you, and this is by way of respectful suggestion, once you make those individual determinations in relation to each suspect, you will have your categories at that stage. But there, as Mr. Greenie recognised, there would, and as you suggested to him, there would need to be an individualised decision-making process to reach that point. Moving on then, sir, to the Article 8.2 qualification issue. I have a lot less to say about that because it doesn't appear to be that there's a huge amount of disagreement between any of the core participants in relation to the principles that apply. The first requirement is whether the interference is in accordance with the law. Our position paper flags up the Inquiries Act and the associated rules, and we suggest that's likely to satisfy that requirement. Our position paper also flagged up at number 2 then that any interference is in pursuit of a legitimate aim, and one which must be specified within Article 8.2 itself. And everyone's written submissions to you on this issue have identified the same legitimate aim, and that's the protection of the rights and freedoms of others. And in particular then, within that legitimate aim, the non-state core participants' Article 2 rights under the Convention under the procedural limb, I should say, of Article 2. So really, for those suspects who do have and are found by you to have a reasonable expectation of privacy, the key consideration in relation to whether or not any interference with that by disclosing their information on their names to the court participants. It's likely to be at the proportionality determination at the end of the Article 8.2 process. And I was going to take you to the bank mellet for questions. In light of the fact that my learned friend Mr. Greeny's already done so this morning, I don't feel the need to do that again. I'd simply observe this, sir. Most of the considerations which have been flagged up to you by the respective core participants in their written submissions will fall to be considered at the fourth stage of the bank mellet process. That's where one is balancing the rights of the individual with the rights of the general public. That's where things like the importance of the inquiry will come into play. Also, I respectfully suggest to you the importance of the principle of open justice, which has been referred to by several of the lawyers involved. At that stage, what the decision maker is required to do is set the scales. On the one side, the rights of the individual. On the other side, the competing public interest rights, and ultimately make a value judgment in relation to that balancing exercise. Third thing then, sir, I'd respectfully address you on is this, the significance of the limited nature of the disclosure at this point. So it is, as you've articulated earlier today, and also Mr. Greeny and your team in their position paper, all we're talking about at this stage is disclosure of the names, potentially, of suspects to the core participants, who are all bound by confidentiality undertakings, not the release of those names into the general public arena at this stage. The significance of that is that the smaller the audience, you may feel the easier it is to justify the interference with the right. Now, that doesn't mean simply because it's a smaller right, one can automatically, lawfully interfere with it, but it's the size of the audience, which is a relevant consideration into the justification. My learned friend Mr. Greeny also raised the issue of a restriction order. Now, and asked for the respective contributors today to address their minds to it, and if they saw fit, address you specifically on the issue. The core participants are subject to the confidentiality undertaking, and therefore ought not to release any information given to them wider than beyond the use which is necessary for the purposes of the inquiry itself. That provides a degree of protection to the Article 8 rights of the suspect. The non-state core participants are not subject to convention obligations, as the inquiry is, as HMG are, and as the PSNI are. And it may well be that you feel that the added protection that a explicit restriction order would provide would be a useful thing in the event that you ultimately decide the suspect's names should not be redacted in this first round of disclosure to the CPs. The other topics that I'd noted, sir, were the issue of notice to the suspects themselves. I'm happy to address you on that and develop that if you wish. I'm happy also to leave it on the basis of what I put in my position paper in writing.
Could we just go right back to the very beginning, please, Mr. Henry?
Certainly, sir.
Just to be sure that I've understood you properly. In Mr. Greeny's introductory observations and submissions, he suggested there were two questions which PSNI might address. Whether the inquiry should take into account the principle in the decisions that are made as to disclosure of documents that name suspects, or whether I should rule that disclosure should not be made in any or some sets of circumstances. And I suppose drew attention to the fact there wasn't a restriction order in place. And you explained to me you had no intentions of intimating a restriction order at this stage.
That's a fair observation, sir. And it's not a police, there is no written application before the inquiry on behalf of the PSNI saying we believe the following suspects' names ought to be redacted from the information which is set before the CPs. The restriction order that I mentioned a moment ago is in the event that it's at a later stage, in the event that you make a decision that that information should be released to the CPs, you may feel that that provides you an added degree of protection to the Article 8 rights in question.
Well, I follow that, but I just want to be clear about what your position is on the matter of the approach to be taken to the question of whether the names of suspects as disclosed in documentation provided by PSNI should be disclosed to core participants. Are you suggesting that that's something that should be left to the inquiry, or are you explaining that PSNI will have a role in that as well?
It's the former.
Yep.
You are the decision maker, sir, and ultimately in this scenario, and we respectfully leave the matter with you. All we've sought to do through, first of all, our written submissions and now this oral exchange with you is to try and set out as best we can the legal principles which we think you ought to consider and try and assist you as much as we can in that regard.
Well, I'm grateful to you for that. That's very helpful. Thank you very much indeed, Mr. Henry.
One final matter that I would touch upon, sir. We mentioned the issue of two matters, I beg your pardon. Competing convention rights, Article 8 versus Article 10. We don't intend to, we've provided some of the general guidance in our speaking note or skeleton argument in relation to that. We don't intend to advance any further observations about that. The second and the true final issue is that of sensitivity, because we did raise that in our written submissions to you. But at this stage, given that we're dealing with issues in general terms, as I referred to earlier, effectively in the abstract, without reference to specific documents, specific names, and so forth, we're not going to be in a position to assist any further with that. We simply put those two observations about sensitivity in the written note so that the inquiry would have them on its radar, but we don't advance any position beyond that. So those are my respectful observations, sir. And if you have no further queries, I'll draw it to a conclusion. I'm grateful to the stenographers for sitting on for that as well.
Thank you.
Grateful to Mr. Henry for being faithful to his time estimate. And in just a moment, we will invite you to break for lunch. But it may assist core participants if we indicate first the order in which we will invite submissions from them this afternoon. And the order is as follows. First, when we return, we will invite submissions on behalf of the Police Ombudsman, Northern Ireland. Then submissions on behalf of those represented by John McBurney solicitors, followed by submissions on behalf of those represented by Logan Corrie, Campbell and Hawhey and Roche McBride. Then submissions on behalf of the Rush family, Following that, we will turn to invite submissions made on behalf of media organisations. First of all, Mr. Mullen on behalf of a number of organisations represented by him. Then Jess Glass, who will appear by a remote link, as I understand it, to make submissions on behalf of the Press Association Media Group. And finally, for today, we will invite any submissions that Lara Smith Council wishes to make on behalf of Media House UK Limited. It may be, sir, that some of those we have just named wish to do no more than endorse the submissions that you have heard made by Council to the inquiry this morning. We anticipate that we will get through all of the remaining submissions, with two exceptions that I'll describe in a moment, well before 4:30 today. But if we do reach the end of those submissions before 4:30, we will not be able to go any further for good reason of which you are aware. And then tomorrow we will hear submissions on behalf of those represented by Fox Law, and as I have said already, we anticipate making some, I would hope, short closing remarks as the inquiry legal team.
Thank you. So what time would you suggest we sit again, Mr. Green?
I was going to suggest, sir, that unless it would cause a problem for you or anyone else, that we return at 2 o'clock.
It may not give people terribly much time, and we do seem to have
We do.
time in
Well,
hand.
perhaps I was being mean. So perhaps we could return at 2:15.
Yes.
2. Thank you.
Right. Bear with me a moment, Mr.
Of course, sir, yes.
Yes.
So thank you. As I indicated before lunch, we would do. The first submissions we'll hear in this session are submissions on behalf of the Police Ombudsman Northern Ireland, and Simon McKay will be making those submissions.
Good afternoon, sir.
Mr. McKay.
Sir, I think height-wise I'm somewhere between Miss Fee and Mr. Henry. Can you hear me okay with the microphone where it is?
Yes, I can. Thank you.
As Mr. Green has indicated, I'm Simon McKay, counsel instructed by the Police Ombudsman for Northern Ireland by her solicitors, Mr. Sally and Miss Coulter. The following short submissions are intended to augment the written submissions dated the 7th of May 2025, lodged on behalf of the Police Ombudsman, and are intended to address the remaining questions raised in Counsel to the Inquiry's note dated the 14th of May 2025. Before addressing those questions, the Police Ombudsman makes the following two brief submissions on the issue of disclosure more generally. First, it may assist to restate, as Counsel to the Inquiry has this morning, the uncontroversial position that there is a distinction to be drawn between the revelation of material to the inquiry and the dissemination or disclosure of that material to other parties by the inquiry. Revelation of material is the singular duty of a recipient to a request under Rule 9 of the Inquiry Rules 2006 to comply with. There is no basis upon which any party subject to a request under Rule 9 can unilaterally redact or withhold revelation of materially lawfully requested by the inquiry from the inquiry, nor is it suggested that this is being proposed in the present proceedings. It was, however, the position in IAB, and there's an important factual distinction to be made between that case and the present proceedings, but I'll come back to that shortly. The inquiry may determine what, if any, material it holds is potentially sensitive before disclosing it to another party or releasing it into the public domain. This is an evaluative exercise and does not contemplate and would be inconsistent with a class-based approach in my submission. In relation to this material, an application can be made under Section 19 of the Inquiries Act 2005 and Rule 12 of the 2006 rules restricting disclosure. The effect of a successful application, as has been intimated, is that a restriction notice or order may be imposed in respect of that material. It is open to the inquiry under Rule 12, as counsel to the inquiry has observed in his note dated the 14th of May, to disclose material to persons that might not otherwise be entitled to see it on the basis that it is held in and subject to a duty of confidence. This is a decision for you as chairman, but it is clearly legally significant that you are empowered to do so. And such material disclosed at that stage is held in confidence and is not for wider publication. Second, in approaching whether to impose any restriction, it is submitted on behalf of the Police Ombudsman that the judgments of IAB and FM Holdings Limited are capable of being distinguished and do not establish principles of wider general application as they relate specifically to judicial review proceedings. Any reliance placed on them should, at their highest, in my submission, be to provide analogical force to the inquiry's analysis only and not bind it. The duty of candour in judicial review proceedings is a long-standing and established duty that is distinct from those arising in other types of proceedings, principally because of the constitutional origins of public law. The nature of the challenges before the court in such cases are always inexorably linked to decisions and, importantly for present purposes, decision makers. The identity of decision makers takes on a particular significance in my submission within such proceedings, as they may provide the underlying explanation, as it's been referred to earlier today, behind the decision. This is recognised in the long line of authority beginning with ex parte Huddleston in 1986, a case already referred to by Mr Greenie KC this morning, in which Lord Donaldson emphasised the existence of the duty, the reasons for it, and its intrinsic relationship specific to public law proceedings. IAB and TFM are the latest decisions in that line of authority. So, candour in the context of a statutory inquiry is a much broader concept. You, sir, in an inquiry, and to quote you this morning, cast your net more widely and is qualitatively different. Counsel for the inquiry this morning invited reasons for this to be identified where possible. In my submission, they may include the following. The search for the truth goes beyond the limitations of any one decision. Secondly, it is more analogous to the scope of investigation in a criminal or civil inquiry. And thirdly, includes not only that which is relevant, but that which may put in train a particular line of additional inquiry or may have some bearing on the issues or surrounding circumstances. For those three reasons, we say that the duty of the candour in the context of public inquiry proceedings is wider than that considered in public law proceedings. But importantly, sir, the Police Ombudsman submits that it is not necessary for the inquiry to resolve the issue of whether a duty of candour applies in the public law sense to a statutory inquiry, or how it may differ between the two types of proceedings. The issues on the application or applications are capable of being resolved without doing so and by reference to existing freestanding legal principles. The position of the Police Ombudsman on the two outstanding issues is as follows. 1. Civil servants. First, in respect of the request by HMG to redact junior civil servants' names, the Police Ombudsman's position is, on relevance, 1. The determination of relevance is a matter for you as chairman in the exercise of your discretion. It is a basic tenet of the law of evidence that only relevant material is or should be admissible. It follows that if the inquiry determines on the facts of the individual case that a name of any particular civil servant, junior or indeed senior, is not relevant, it does not fall to be disclosed. That determination must be made, as counsel to the inquiry has submitted this morning, only when the inquiry is able to make an informed decision on relevance, no doubt with the assistance of core participants, as is proposed. It would be inconsistent with the concept of open justice to start with a position where names are redacted, as is proposed by the Secretary of State this morning, but later reviewed subsequently. That is to look at the issue, in my respectful submission, from the wrong end of the telescope. On privacy, an assertion that there is an expectation of privacy imposes, firstly, an evidential burden on the party asserting it. However, and in any event, no expectation of privacy arises or is likely to arise where the information is already in the public domain. Public servants may, indeed probably do, have a reduced expectation of privacy. The Police Ombudsman would respectfully agree with Mr. Justice Swift in IAB that there is no general expectation. That is different from where specific expectation arises in particular circumstances. Sir, as the submissions have evolved during the day, you have asked what authority might exist to establish private rights that may extend to the workplace. The following submission is simply to assist the inquiry. If it doesn't, you'll ignore it. But you may consider that the appropriate authority is the well-known decision in Nemitz and Germany. It's not in the bundle, sir, because it's only arisen during your interactions with counsel this morning, but it's a well-known authority and can be provided to the inquiry if it assists. In that case, the European Court of Human Rights held that the European Court of Human Rights increased the scope of the notion of home to include business premises and relationships. At paragraph 29, the court held it would be too restrictive to limit the notion of an inner circle in which the individual may live his own personal life as he chooses, and to exclude there from entirely the outside world not encompassed within that circle. Respect for private life must also comprise to a certain degree the right to establish and develop relationships with other human beings. There appears furthermore to be no reason in principle why this understanding of the notion of private life should be taken to exclude activities of a professional or business nature, since it is, after all, in the course of their working lives that the majority of people have a significant, if not the greatest, opportunity of developing relationships with the outside world. That case is not a case that was referred to in IAB either at first instance or the Court of Appeal, as far as I can tell, with the limited time available to research the issue. There may be, sir, a distinction between junior and civil servants in the context of expectation of privacy. That is a question of fact, as Swift J noted in IAB.
Can we just pause for a moment and
yes,
just sort of flesh out a little more about the European Court of Human Rights case? What do you say the effect of it is? The effect of it is to extend, in principle, the expectation of privacy into the workplace. It's no more than that. That does not... To what effect? There may be, in certain circumstances,
an individual expectation of privacy that could arise because of someone's employment.
Because of what, sorry?
Somebody's employment. I don't think it changes the practical effect of the approach that the inquiry will take, but what I think is important is that the Article 8 is a broad notion, it's a broad concept, and the starting point would not be to exclude certain activities from the concept of private life, but rather to take a broader and more liberal approach to it. Whether in an individual case an expectation arises is a matter for the inquiry. And let me make it clear that the Police Ombudsman agrees with Mr Justice Swift in IAB that there is no general expectation. It would have to be fact-specific, arise on the particular facts of the particular case.
And part and parcel of that consideration would no doubt be what he also said about civil servants, namely that they perform a public function in the public service.
Yes, sir. And as you're aware, in the written submissions that the Ombudsman has filed, she has referred to the Information Commissioner's Office guidance on the revelation of names subject to a Freedom of Information Act request. And we say that there is some helpful methodology in there to understand what the principles are at work. What the Information Commissioner's Office is doing is recognising different levels of expectation, first of all, and first of all, what the Information Commissioner's Office recognises is that the right extends to the workplace. First and foremost, that seems to me to be what the ICO is saying. Second of all, that there may be a distinction between the seniority of the individuals concerned, but specifically is saying that in determining whether there is a specific expectation of privacy arising in the particular circumstances, it will all depend on the evidence that's available to the decision maker. And that's one of the things that's not before you, sir. I mean, there's a complete dearth of evidence before you as to whether any of these civil servants that have been referred to, in fact, wish to make an assertion that their privacy is being interfered with. And it seems to me that one of the things that that emerges clearly from the principles is that there is an evidential burden on the person making the assertion to prove it, and you don't have that evidence. But it would be a wrong, in my respectful submission, to approach the issue on the basis that there is no expectation. One must approach it in a broader sense.
Yes.
In fact, I was about to go on to say, sir, that is a question of fact, as Mr Justice Swift noted in IAB, and the inquiry would need to resolve if evidence, and as I say, there is no evidence before it presently, if evidence is placed before it in support of an assertion that an expectation arises in an individual case. No such evidence or sufficient evidence is presently before you to enable you to make that decision. On the question of risk, sir, an application that redaction should take place on the basis of risk also imposes an evidential burden, but the threshold is significantly higher and not easily crossed. That is the effect of the decision in Re Officer L, a case that appears in my submissions, but I'm not quite clear whether it's made it to your bundle, but it's a well-established and uncontroversial principle. Again, there is no evidence currently before the inquiry to enable it to make that determination. Second, there is no basis in law for a class exemption in respect of either relevancy, privacy or risk, and certainly not one on the grounds of expediency. Indeed, it is antithetical to the correct approach to the determination of such issues, which requires a careful balancing of important but often competing rights by the inquiry. That is the exercise of proportionality in action. An application needs to be made specific to each case, supported by evidence, and a determination made by you, the chairman. Equally, there is no basis in law for a conclusion that membership of a particular class, in the present case the civil service, of itself automatically excludes the possibility of an expectation of privacy arising in an individual case. So is there anything arising about the submissions made so far on the issue of civil servants?
No, thank you.
I'll just turn to suspects, if I may. The Police Ombudsman agrees with the Inquiry's Council's analysis that the names of suspects in any of the 4 categories identified should not be redacted at this stage, in addition to the reasons set out in her written submissions. To adopt the language of the Supreme Court in Sutherland and HM Advocate, none of the conduct, and picking up on Mr. Henry's submission this morning, that's what's relevant here, the nature of the conduct. None of the conduct engaged in is capable of respect within the scheme of values which the Convention exists to protect and promote. Although neutral on the issue, the Police Ombudsman submits that naming the suspects is a decision plainly open to the inquiry and supported by the existing jurisprudence. That will need to be, as you have previsioned in fact today, considered on a case-by-case basis in due course. Further, and in addition, in developing this point, a couple of practical or procedural issues may arise based on the submissions you've heard this morning. First, the inquiry must have before it a relevant application under Rule 12 in order to consider a derogation from full disclosure. And it's become apparent that that's not before the inquiry as things stand. Second, it's not clear to the Police Ombudsman that anyone other than the suspect can make the assertion of non-disclosure on the grounds of privacy. Although it may be possible for a public authority to advance alternative grounds for the withholding of material on behalf of a third party, such as, for example, prejudice to an investigation or an ongoing trial, that is not the case in respect to privacy. This is an important issue of standing, we say, and may give rise to a procedural requirement to take reasonable steps to either invite those suspects who may be named to make such an assertion if they wish to do so, or put them on notice of the intention to release their names into the public domain and invite them to provide any objections to such a course. So unless the Police Ombudsman can assist you further, those are the additional submissions that she wishes to make in addition to those she's already filed in writing.
I'm interested in exploring something that you've just said, Mr. McKay, which I think ties in with some of the observations in your written submissions. And it's to do with the nature of the conduct engaged in.
Yes.
And as I understand what you've said this morning, you would say that none of the conduct engaged in is capable of respect within the sphere for which the Convention exists, and accordingly that the names of the suspects should not be redacted at this stage.
Correct, sir. The underlying analysis for that focuses on the word respect in Article 8, which hasn't been emphasised particularly significantly so far when reference has been made to it. But the rationale in Sutherland was the right to respect for private and family life. And the Supreme Court justices in that case took that through to its logical conclusion, that where an individual is engaging in activity that is not deserving of respect, no expectation of privacy can in those circumstances arise.
Well, I'm just wondering how that falls to be determined. You've explained in your written submissions, for example, at paragraph 24, that the nature of the conduct or offending and where and how it occurred would be significant in determining whether an objective expectation of privacy arises. So that's slightly different from just saying that because someone's a suspect, their name should be their name should not be redacted. I think what that would convey to me is that if someone is a suspect, then a little bit more consideration should be given to whether or not their name should be redacted.
Yes, sir. It essentially comes back to the application of stage 1
Yes.
that I deal with at paragraph 14 of the written submissions. And that is the adoption in Bloomberg by the Supreme Court of the Court of Appeal's analysis in Murray,
Yes.
where it identifies, I think, non-exhaustive factors determining whether the expectation arises. And certainly these are the principles that the Supreme Court in JR 38 found particularly persuasive. In JR 38, so you might recall the case, this is a young rioter, I think in Derry, Londonderry, who was caught on camera by a reporter. And it was proposed that his photograph did appear in the local and regional press, and a challenge was brought against it.
Yes, I know the case.
Yes.
But in that case, the question was whether the publication of his photograph was a breach of his Article 8 rights. And one of the factors, despite his youth, which contributed to the court concluding that there was no breach, was the nature of the activity that he was engaged in.
So yes,
He was pictured rioting.
yes,
But that's not what we're talking about. We're talking about the question of disclosing the names of individuals who are investigated by the police. And that investigation will no doubt have been triggered by all sorts of different pieces of information. But it's highly unlikely, I'm assuming, that any of that will constitute photographs of them actually engaged in terrorist activity.
No, the issue isn't the issue isn't whether it was photographed. The issue is whether it's in the public domain. The taking of the photograph was incidental in JR 38. The question was the publication of him engaging in the conduct. So the question that would then fall to be asked in my submission would be, in relation to the suspects, to what extent is the nature of the conduct that they've engaged in already in the public domain? Has there been, for example, a trial? We know that there's been at least one criminal trial, for example. So in relation to that individual, it seems to be unsustainable that one could sensibly make the case for the redaction of the name that everyone will know what we're talking about.
Well, I don't think anybody would quarrel with that. But the more difficult question, surely, is what's to be done with someone who is investigated as a suspect and who, in accordance with the law in Bloomberg, is entitled, at least as a starting point, to protection of that fact from publication. Now, the investigation is into whether or not he committed a terrorist act. And let's assume he's a suspect for that. You're not saying, surely, that just because he's a suspect, he doesn't deserve protection of the fact of the investigation?
No, we're not saying that. We're just saying that in fact, we're saying the opposite. The starting point is he is entitled to the expectation of privacy. What we're saying is that one must then follow a methodology to reach the outcome. And one of the considerations that you will have regard to is whether the nature of the conduct was engaged in a public place. Or, for example, if it went to membership of a prescribed organisation, that is not something that would be deserving of protection because of its nature. So one comes back to what might be called the Murray factors and works through them. But let me make it clear, the Ombudsman isn't being declarative about what any of the outcomes should be, but rather what the principles are. So you might think
The nature of the activity, as you would see it, in the Murray interest, is a question of the extent to which it's public knowledge.
or takes place in in the public domain. I think Kinloch is a better example, so because you're talking in Kinloch about the observation of a suspect on the streets of Glasgow by police officers without the necessary authorisation in place. And what the Supreme Court said in Kinloch is that the nature of the activity taking place in a public place wasn't something that was deserving of respect for his rights under Article 8 of the Convention. And that would be the same broad analysis that would take place in relation to that aspect of whether you decide to redact or not redact suspects' names.
So how am I going to follow that up? Am I going to have to conduct some sort of inquiry of PSNI as to the basis of their suspicion for each individual suspect?
No. The real question will be to what extent their involvement in the conduct that you are concerned with is already in the public domain for the purposes of that principle.
But won't that require me to ask PSNI why they suspect this person?
Well, it may do. It may already be obvious for the reasons we've described. There's already been a public trial and a publicly available judgment about that.
I think that's unlikely, because in that situation we'll not be taking up terribly much time to consider it. That'll be a perfectly obvious decision.
Yes.
But there'll be many, I assume, where the decision is far more difficult and far more nuanced considerations will need to be taken into account.
Yes.
And if the nature of the conduct that the person is engaged in is something I've got to take account of, then I need to know how I'm going to go about that.
Well, Sarah, forgive me, but first of all, I'm only trying to help the inquiry. And second of all, the nature of the conduct is the conduct you're concerned with. So it's conduct that you will already be aware of and may be germane to the inquiry's terms of reference. There ought not to be anything surprising about the nature of the conduct in issue, unless we're talking at cross purposes. We're referring to suspects.
Yes.
So there must be information available that points to them as being suspects. So what we wouldn't anticipate is there being some prolonged inquiry as to what the nature of that evidence is. Certainly part of that inquiry would be whether the nature of that evidence supports the fact that it was taking place in a public place. Taking a hypothetical example, a conspiracy taking place in a safe house is not taking place in a public place. But other conduct that might have been and maybe the subject of, for again hypothetically, I'm not suggesting this has arisen in this case, took place in a directed surveillance operation in the streets of Belfast or Omagh or some other location within the United Kingdom. Well, if that is part of the evidence that forms the basis upon identifying that individual as a suspect, that is conduct that took place in a public place and is not deserving of the rights afforded to that individual under Article 8 of the Convention. But so you're absolutely right. Of course, this is a very nuanced decision for you to make, and a difficult one. On behalf of the Ombudsman, we're attempting to identify, in a sense, a route to the decision.
And would that conduct have to constitute criminal conduct?
Well, it would have to constitute conduct not deserving of the rights afforded under the Convention. So it may be criminal, but it may fall short of criminal. For example, in many of the well-known privacy cases, it's involved engaging in recreational drug use or other related activity, where the courts have held that the nature of that activity isn't something that would be deserving of respect under the Convention. But it's an evaluative exercise.
Yes. All right, thank you. Did that conclude your submission?
It did, sir, yes.
Thank you very much. Mr. Greenie.
So thank you. We're now going to hear from Michael Smith on behalf of the bereaved families and survivors, represented by John McBurney, solicitors.
Good afternoon, Mr. Smith.
Good afternoon, Chairman. By way of introduction, I appear for the John McBurney Core participants, and I'm assisted in that by my learned friend, Miss McMullen, who's here today, and also by King's Counsel Alan Kane, who I understand is participating via the online link. Can I say, sir, that at the outset we rely primarily on the written submissions that were provided to the inquiry by us on the 30th of April and on the 7th of May, and those are set out at pages 45 to 57 of the submissions bundle. I'd like to take this opportunity, sir, to make some brief points on behalf of the John McBurney Court participants regarding the two issues which are under consideration in today's proceedings. Prior to doing so, sir, I would first like to endorse the provisional view set forth on both of those issues as presented by counsel to the inquiry in his note dated the 14th of May. All of the comments that I will make are made conscious of the fact that the degree of redaction being considered at this stage is redaction or otherwise to the core participants, as opposed to the issue that will be dealt with at a later time, namely redaction from the general public. If I could deal firstly with the issue of the redaction of names of junior civil servants. On behalf of the John McBurney Court participants, I would express their dissatisfaction at the apparent diluted candour which they perceive in the approach which has been taken by both HMG and the Secretary of State. And I would further take this opportunity, Chairman, to reiterate their full confidence in the inquiry to strongly discourage such an approach in order to fully maintain the openness and transparency of these proceedings. In response to the submission by HMG that there should be a redaction of junior civil servants' names on a class basis, it is important, we feel, to re-emphasise the question as was framed by Mr. Justice Fordham, which we have quoted in our written submissions at page 47 of the bundle, which is namely this: that judges should not write a judgment asking, is there a necessity for giving this name? The question has to be whether there is a necessity for protecting someone's identity. The HMG submission to the inquiry on redaction by class is in direct contradiction, we feel, to the legal authorities, all of which have been properly considered by counsel to the inquiry. It is the hope of the John McBurney Court participants that the inquiry will strongly resist any impracticalities which might be suggested, insofar as they might enable those legal authorities to be circumvented. The final point that I will make on this issue of redaction of the names of junior civil servants, sir, is to say that regrettably this inquiry is taking place almost 27 years after the Omagh bombing. That passage of time has significance in terms of the career progression and in some cases retirement of the junior civil servants who are now being discussed. That is a real world consideration for the inquiry to take into account as it moves forward. On the second issue under consideration today, the redaction or the proposed redaction of names of individuals suspected of involvement in the Omagh bombing or in other related terrorist incidents, may I say this? On behalf of the John McBurney Court participants, the provisional view on the redaction of suspects' names, as expressed this morning by counsel to the inquiry, has been warmly received, as it has clearly taken into account their early concerns. In particular, the John McBurney Corps participants strongly shared objection was that the inquiry, when looking at all the related terrorist incidents that occurred in 1997 and 1998, should not hesitate to bring into the light for their consideration the identity of each and every suspect connected to any of those incidents, regardless of whether they were dissident or otherwise. Counsel to the inquiry has invited comment from Corps participants on the 4 categories which were identified at paragraph 25 of his note to the inquiry. Can I say, Chairman, that we have no contrary view to either the categorisations used or to the proposed degree of redaction set out. Thank you, Chairman, for the opportunity to make these oral submissions and have them added to our written submissions. Is there anything that you would wish me to comment further upon, sir?
There's just one thing I'd like to be clear about. I think from what you've just explained, you're content with the general approach suggested by counsel to the inquiry in relation both to identifying the 4 categories and to identifying the approach that should be taken in each category.
That's correct, sir.
But there was one thing in your written submissions that seemed perhaps to me to go a bit further than that. I'd maybe just like to be clear about it. At paragraph 13 in the submissions in relation to this matter, you set out that all suspects should be named unless there's clear and reliable exonerating intelligence or evidence which confirms that they were wrongly identified as suspects in the first place. Now, that seems to be quite a far-reaching proposition.
Well, at the point that that paragraph was drafted, we hadn't yet had sight of counsel to the inquiry's note, and that paragraph perhaps looks further down the line towards the issue of redaction from the general public and under what circumstances that might be permissible. At this stage, dealing with redaction only to or against the Corps participants, I'm not sure that that's a point which needs to be dealt with today, but it can be expanded upon at the relevant stage.
Yes. Well, that's helpful, thank you. I just wondered really where the concept of the presumption of innocence would sit within that. But that's something you can help me with at a later stage, if necessary.
We will do. Thank you, sir.
Thank you.
Thank you, Mr. Smith. So Mr. McGuckin appears on behalf of the families represented by Logan Corrie, Campbell and Hawhey and Roche McBride. And I've had the opportunity to speak to him on a number of occasions over the course of the day, including at lunchtime. And he would simply wish me to indicate on behalf of the families that he represents that they are entirely supportive of the position expressed by counsel to the inquiry this morning.
Well, that's helpful. Thank you.
I've also had an opportunity to speak to Miss Roundtree, who appears on behalf of the family, the Rush family, represented by Elevate Law, and she similarly has explained to me that she wishes me to indicate on her behalf and on behalf of the Rush family that they are entirely supportive of the submissions made this morning by counsel to the inquiry.
And neither wish to present any further submissions.
And as I understand it, neither wishes to present any further oral argument to you. So we are grateful to them. Next then, sir, we turn to receive submissions on behalf of the media organisations, and I'm going to ask Mr. Sean Mullen, who is immediately to my right, to go to the lectern and to make the submissions that he wishes to make orally by way of supplementing or developing his written submissions on behalf of UTV, the National Union of Journalists, BBC Northern Ireland and RTE.
Good afternoon, sir, and hopefully you can hear me. If at any point my voice drops or you cannot hear me, of course, do not hesitate to let me know. Sir, I am here today representing the media organisations, the BBC Northern Ireland, UTV, RTE and the National Union of Journalists. I'm instructed by Miss Olivia Kane from DWF. I should say at the outset, Lord, or Sir, I do intend to be very brief in respect of my submissions here today. You have had the benefit of our written submissions filed on the 12th of May. At that stage, we had not had sight of the very, very helpful note from the Council to the Inquiry. We have now had sight of that note from the Council to the Inquiry, and we respectfully agree with the content of that note, Sir, and we would adopt the submissions made therein in respect of the approach to be taken and the approach in regard to the naming of suspects. And I should say, just for clarification, in terms of the naming of junior civil servants, we take no issue in respect of that, and we leave that as a matter for the inquiry, Sir. So in terms of the written submissions which we have advanced, we have set out the public function of the press, Sir, the watchdog nature, the interests of open justice, and we would rely upon those in terms of any assessment or exercise that is carried out by the inquiry. We respectfully agree, as I say, Sir, in terms of the Article 8 exercise that must be carried out in respect of the suspects. We again agree in respect of Article 8.2 in the test of the accordance with the law and the necessary protection of rights or freedoms of others. What we say clearly in terms of that assessment is that the Article 2 procedural rights for the bereaved families and the victims are very powerful, and that is obviously a weighty matter for consideration for the inquiry. At this stage, and we are grateful, Sir, for the focus that was brought by Senior Counsel to the inquiry in terms of the moving matters along, given that this is at the limited stage in terms of disclosure at this stage to the court participants, we say that the Article 10 rights of the media are somewhat limited in respect of that. We say that there is a potential factor for consideration because names going forward at this stage could stimulate further input from the families, the bereaved families and court participants. So we say that that is a factor for consideration, but accept that at this stage, Sir, it is perhaps more limited than it would be available at the more later stage in terms of public disclosure. As I say, Sir, we agree with the categorisation of the suspects set forward at page 105 in the note to the inquiry set out at paragraph 25 therein, the 4 categories of the suspects in terms of the reasonable expectation of privacy and also where there is a reasonable expectation of privacy, the Article 2 presumption for the bereaved families would counterbalance that. So those 4 categories we agree with, and in terms of disclosure to the court participants, we say that any exercise in terms of that assessment, we leave that to the inquiry at this stage because it is on the limited basis for disclosure at this stage, Sir. Unless I could be of any further assistance, Sir, at this stage, I tend to rely upon the written submissions, and we, as I say, we intended to keep it as focused as possible.
There's just one thing that I'd like to canvass, and it's really just of a very general nature. In your original written submissions, much emphasis was understandably laid upon the function of the press and the value and scope of Article 10. And much was said about the principle of open justice. But I think you would recognise that all of those principles and statements probably form the context in which sections 18 and 19 of the Inquiries Act came to be legislated for by Parliament. So in Section 18 of the 2005 Act, there is the obligation to hold inquiry proceedings in public. But of course, it's not an unfettered obligation. And something was said about the reading across between open justice principles as they apply in court to open justice principles as they apply to an inquiry. But I'd just like to be sure that there's no disagreement amongst us about this issue. If we look, for example, to Kennedy against Charity Commissioners, at paragraph 125, we see the statement, 124, I'm sorry, we see the statement that the considerations which underlie the open justice principle in relation to judicial proceedings apply also to those charged by Parliament with responsibility for conducting quasi-judicial inquiries and hearings. So that's what we're doing. But then in the very next paragraph, the court goes on to say, the application of the open justice principle may vary considerably according to the nature and subject matter of the inquiry. A statutory inquiry may not necessarily involve a hearing, may be conducted in other ways. And it says the subject matter may be of much greater public interest or importance in some cases than in others. And two or three other comments of that sort are made and drawn together in paragraph 128, which reads, such enactments, those that create inquiries, may go into greater or less detail about how an inquiry is to be conducted. The Inquiries Act of 2005 contains detailed provisions about the conduct of an inquiry under that Act. Other acts which provide for inquiries may be less detailed. To the extent that an enactment contains provisions about the disclosure of documents or information, such provisions have the force of law. But to the extent that Parliament has not done so, it must be for the statutory body to decide questions of disclosure subject to the supervision of the court. I don't see the absence of a prior statement by the courts that in general the principle of openness should apply, subject to any statutory provisions and subject to any countervailing reasons as a convincing reason for not saying so now. So what I would understand the court to be saying, and I'd be grateful for your comment on, is that open justice principles apply in relation to inquiries, but only subject to the statutory provisions set out under which the inquiry is governed.
Yes, sir, I think that is correct. Obviously, from the media's perspective, we want as much to be aired as public as possible, subject to any decision of the inquiry to the contrary, and of course any decision made therein would only be made in certain limited circumstances and for very good reasons. I suppose the media approach this very much so within Northern Ireland from the victim's perspective, a victim-centric approach in terms of trying to get further information out there. It may lead to further inquiries in due course, further information coming forward. All of those matters are very important parts of with the media function here, sir, and that is what the media are trying to do, trying to assist the public in general, because it is such an important topic within Northern Ireland and for the bereaved families. And of course that's where we're trying to focus on, and we were trying to come from the angle that we approach on. I accept that there's a case-by-case basis in due course. Individual assessments will have to be carried out in terms of suspects. That's perhaps for further down the line, so to speak, sir. In terms of the aspect today, we do accept and we adopt the position by counsel to the inquiry, and our position would be that the names of the suspects should go forward to the court participants at this stage, sir.
But I suppose the important point, in my mind at least, is that unlike, for example, a criminal trial, a statutory inquiry conducted under the 2005 Act has the opportunity in appropriate circumstances to hear evidence in private which cannot be published.
Yes.
And that's recognised.
Yes, absolutely, sir. Yes, that's entirely correct.
All right. Thank you very much indeed.
Thank you very much, sir.
Thank you, Mr. Mullen. So the next submissions you will hear are from Ms. Jess Glass on behalf of the Press Association Media Group, the PA Media Group. She will be appearing by a remote link, a video link, and we will need 5 minutes in order to set up that link. So could I invite you, sir, to rise for 5 minutes or until we are ready, whichever is the longer.
All right. Thank you. Mr. Green.
So thank you. I'm told that the link is now established. And assuming that that is so, I'm going to ask Ms. Jess Glass to make her submissions on behalf of PA Media Group.
Good afternoon, Chairman. Can I firstly check that you can see and hear me?
We can. Thank you very much.
Thank you. I'm very grateful to the inquiry for facilitating my remote attendance, and I do apologise for not being there with you in person. As indicated, my name is Jess Glass. I'm the law editor of PA Media, also known as the Press Association. I do not intend to repeat the submissions made by the other parties, and I do plan to be very short, but there are a few key points I would like to raise on top of my written submissions. We respectfully submit that it is difficult to overstate the substantial public interest and the importance in transparency in these inquiry proceedings, given the background in which it sits. We do respectfully also endorse the submissions made by Counsel to the Inquiry. Although PA has limited our written submissions to the suspect name issue, we would wish to briefly touch on the issue of the junior civil servants. The judicial criticism of the practice of redacting the names of junior civil servants, particularly in the IAB case, is a factor that we submit should be given considerable weight by this inquiry. The underlying principle that we do say the judges were reflecting apply to these proceedings. In fact, we would submit it would be actually artificial to only appreciate the comments in the context of judicial review. We would also respectfully submit that HMG's submission that the names of junior civil servants should be anonymised is an overly broad approach and unsupported by authority. It is our submission that HMG have approached the legal test in the incorrect way. It is not the case that a person should be unnamed until relevance or other reasons proved under the open justice principle, bearing in mind the Chairman's recent comments. Instead, it is that the starting point is that a person should be named unless there is a cogent reason to do so otherwise. That cogent reason must be supported by evidence on a case-by-case basis, we submit. We also submit that a purported lack of relevance, as determined by HMG, does not meet this test. The inquiry has been given the witness statement of Sharon Carter made on behalf of the NIO, where she says that junior officials may conduct advisory and management functions as opposed to decision-making roles. PA would say that even advisory and management functions are not insignificant. The so-called suspect point is addressed in our written submissions, and I don't intend to expand further, aside from the fact that our overarching submission is that given the substantial public interest, all suspects should be named, subject to a very high bar to justify anonymity, again on a case-by-case basis. Unless I can insist any further, those are my submissions.
Well, if you are still there, Ms. Glass, thank you very much indeed. And so finally today, I'm going to invite Ms. Laura Smith to make her submissions on behalf of Media House UK Limited. Media House UK Limited being the publisher of the Belfast Telegraph and Sunday Life.
Ms. Smith.
Good afternoon, sir. As indicated by the other parties at this stage, I don't intend to duplicate either the written submissions that I've provided or indeed the submissions made by other parties today. At the outset, sir, it has been correctly emphasised by your counsel and numerous parties today that the issue in consideration today is one that about the disclosure of material to the core participants rather than to the public at large. And I think, and I paraphrase your counsel in his opening remarks, that it may be, he said, that Article 10 does not arise for close consideration today, given that we're concerned with that issue, but that it will be important at a subsequent stage. And I quote, where it is made or proposed to be made beyond the core participants to the public at large. And while, sir, it is certainly acknowledged, as Mr. Mullen did on behalf of his clients, that the issue of dissemination and deployment of that material will certainly engage to a very significant extent the issue of Article 10, in my submission it would be wrong to dismiss the relevance of Article 10 at this stage. And that is because, of course, those stages, Stage 1 and Stage 2, as they've been framed today, are inextricably linked. As we've discussed, the second stage may be one where there is dissemination beyond the core participants to the public at large. But as a matter of fact, if the material is not disclosed to the core participants, there's no realistic prospect of that ever being disclosed to the public at large. And so the approach taken now by the inquiry to this issue will directly impact the ability of the public to have access to information that will, as a matter of course, have been deemed relevant to the inquiry's terms of reference. And that's the important starting point, we say, that will impact the ability of the public to be informed about matters and for the press to perform what you've already recognised is the very important role as the public's watchdog. Turning briefly to the specific issues before the inquiry today, on the issue of the redaction of the names of suspects, we endorse and adopt the submissions already made by your own council, save to emphasise the fact that the procedural safeguards that will need to be put in place in respect of the individualised assessments that will need to be carried out by the inquiry in due course. And we would emphasise that at that point, the press will need to be given the opportunity to be heard. And at that point in particular, consideration will need to be given to the disclosure of the important subject information, in particular the names, to those representing the media for the purposes of permitting those representations to be both informed and meaningful. Dealing with the issue of the civil servants, on behalf of Media House UK Limited, we strongly contest the approach advocated to be taken by the Secretary of State. It has been noted on a number of occasions today that the inquiry is at an early stage, and the inquiry will no doubt be faced with many more issues of redaction and restriction orders over the next number of years. But this is an important point of time that will therefore set the tone for this inquiry and how the inquiry will approach matters of this nature. The context in which this application arises, as has been noted, is one in which the information sought to be redacted is already protected by the significant undertaking provided by the core participants. In addition, it is in a context in which the inquiry team itself will only be disclosing the documents that are truly relevant to the inquiry's terms of reference. And it is in a context where, even today, it has been emphasised on numerous occasions that the inquiry will only permit the deployment of this material once that has been examined and assessed and its justification has been considered. It is in that context today that the Secretary of State requests that the inquiry redact information on a wholesale basis, on the basis of a specific job title alone, based on entirely speculative rather than specific concerns, as required by the authorities that have been opened to the inquiry today. At one stage in the Secretary of State submissions, it was said that a civil servant's identification as an employee of the state could interfere with his private and family life. And that, in my submission, discloses the fundamental issue with the application being made. There is no place for hypothetical, speculative concerns in the balancing exercise that has to be undertaken by the inquiry. Importantly, as it will not have escaped you, sir, no party, as I understand it, is making the contention that the redaction of any particular junior civil servant's name could never be justified on the grounds of Article 8 or Article 2. What is merely being restated today is the uncontroversial principle that each application has to be considered on its own facts. That approach is obviously consistent with the well-established authorities that I don't think I need to open to the court. But the one being advocated today by the Secretary of State is one that is not consistent with those authorities and is contrary to the need for cogent evidential basis before a departure from open justice can lawfully occur. Because this is at an early stage and at the opening of the inquiry, it is important that the inquiry respond robustly and firmly to this request and affirm the confidence, both for the families and for the public at large, that in this inquiry, any application for a derogation from open justice will be closely scrutinised and only granted where it is grounded in true, firm, legal and cogent evidential basis. In this case, for the reasons outlined by a number of parties today, there is neither. And so we would submit that this should be refused. The only other matter, I think, Chair, for me to address is the issue of the restriction order that has been mooted as a compromise, if I can put it like that. We would make two observations about that. In the first instance, it isn't clear to us if such an order was to be made in the alternative to granting the application made by the Secretary of State, what the legal basis for doing so would be, and that hasn't been articulated today, save for an indication that, of course, it may provide some added assurity. And in our submission, the Chair and the inquiry would need to be very clear on the basis on which such an order would be being imposed. And the second observation, Chair, that I would make about that would be the risk that such an approach would take would be to reverse the burden somewhat, such that it would be for the media or the core participants or indeed a member of the public to apply to set aside that order in due course, rather than for the burden to be placed on the party seeking to restrict the information. Unless I can address the Chair on anything in particular, those would be our submissions.
I'd just like to think about your final submission for a moment. I think what was suggested was the possibility of imposing a restriction order if the submissions of, say, for example, the Secretary of State were not upheld.
Yes.
So that would be in circumstances where I declined to redact the names of junior civil servants.
Yes.
And the consequence of that would be that the documents, including those names, would then be disclosed to core participants.
Yes.
I think what was suggested was that in that situation, I might make a restriction order prohibiting the disclosure of any of the information as so disclosed to core participants to any other party or person. And I think that would that not be, would that fall within the terms of Section 19 of the Act?
It would, save for the fact that the Chair would have to be satisfied that it was necessary to do so. And it wasn't clear to me, given the terms of the undertaking, how the Chair could be satisfied.
You say the undertaking would be enough?
Well,
Sorry,
I think there is an undertaking in place, and that is already there. So I think the suggestion is simply that would copper fasten somewhat, that undertaking, but I'm not sure that what lawful exercise there could be to simply impose a further restriction order. And that it may be that it would lead to nothing, but from my client's perspectives, the concern is it would reverse the burden that we would have to seek to set aside that restriction order in due course, rather than if the evidence was in due course deployed, it would be, as a matter of fact, reportable.
Yes. Well, that's helpful. I'll think about that. Thank you very much.
Thank you.
Ms. Smith, thank you very much. Sir, as I explained earlier, that is for good reason as far as we can go today. Could we finish now and then restart at 10 o'clock tomorrow morning, when we will hear the submissions of Mr. Eamon Foster on behalf of the families represented by Fox Law, and then finally some closing remarks by counsel to the inquiry. I don't anticipate, sir, that it will be necessary to sit much beyond 11 a.m. tomorrow.
Yes. All right. Thank you, Mr. Greenie.